Please, Your Lordship. Lordship, I beg to mention item number 5, 6, 7, and 8. Lordship, here, this matter will be listed tomorrow in the single bench with due apology.
In the second bench.
Yeah, tomorrow we have a GB as well as a single. So,
Tomorrow it may be difficult.
Lordship,
Tomorrow it may be difficult.
tomorrow TP as well as a single. If not Thursday,
Your Lordship, it may come up on Thursday. Since tomorrow there's a division bench.
otherwise we have a single also tomorrow.
Then let it come up after vacation.
Thursday, how about Your Lordship?
Thursday also we have some fixed hearing that.
Yes, Lordship, but in this matter also is just a review petition. It don't take time, Your Lordship. It's a very simple matter.
It don't take time. Definitely, Your Lordship.
Let's try, Your Lordship, so that if the matter keep taken up, we'll take it up, and if not, then we'll adjourn on Thursday.
Okay. On third, Mr. Intim Song. An additional AG. So heard Mr. Supam. Welling, Learned Council for the petitioner. On request of the council for both the sides, let this matter be listed on 19th October 2023.
Lordship.
Lordship, I have filed an initiative bill today, Lordship. This may be taken today, Lordship, as unlisted motion.
No,
Maybe as last item, Lordship.
let it come up tomorrow.
Lordship, there is some difficulties on my part, Lordship. Kindly, Lordship, as last check.
Okay.
Must.
May I please, Lordship, I beg to mention item number 3 and 4. I am for the respondent number 5.
Respondent number?
Item number 3 and 4, my lord.
Yes.
I pray that these matters may be listed after the Puja vacation. Yes, Lord.
Heard Mr. N. Long Kumar. Council for respondent number 3 and 5.
5, 4 and 5.
3, 4, and 5. Who prays for an adjournment. Mr. Supamvati Waling, Learned Council for the petitioner, does not oppose this said prayer. Hence the prayer is allowed. Let this matter be listed after 2 weeks.
May I please, Lordship. Lordship, I beg to mention item number 18 on behalf of the council for the appellant. Lordship, we have taken the counsel from the opposite party, Lordship, to list this matter after the Puja break, Lordship.
Heard Mr. M. Vero, Learned Council for the appellant who submits that he has obtained the consent of Learned Council for the respondents and prays for listing this matter after 2 weeks.
After Puja, Lordship, yes.
The considering the submissions made by Learned Council, the prayer is allowed. Let this matter be listed after 2 weeks.
Obliged, my lord. From the supplementary cost list for judgment, item numbers 19 and 20.
Has to be first. in for the reasons mentioned in the judgment. This is item number 20, writ petition number 123. For the reasons mentioned in the judgment, this writ petition is disposed of with the directions to Deputy Commissioner Woka to refer all complaints received with regard to selection of village council members. Village council members forwarded to him after scrutiny, which was held on 22/3/2021, and the second list, which was sent to him after scrutiny, which was held on 3/4/2021 to the state government for taking a final decision as provided under section 20 of the Nagaland Village Council Act 1978. The state government shall take final decision with regard to the dispute regarding selection of village council members within a period of 3 months from the date of receipt of this copy of judgment. Till a final decision is taken in this regard by the state government, as per section 20 of the Nagaland Village Council Act, the impugned approval order dated 10th June 2021, to the extent as it relates to village council members of the 4 khels of Lakoti village, namely Peton Khel, Yantharo Khel, Heli Khel and Upper Khel, shall remain suspended. However, as regards the other khels of Lakoti village, namely Pangtilan Khel, Humso Khel, Enguli Khel and Ilang Khel, the suspension of the order dated 10 June 2021 is hereby revoked. The extra assistant commissioner shall have control over the activities of Lakoti Village Council subject to general superintendence of the state government under section 22 of the Nagaland Village Council Act during the pendency of the matter before the state government, so that the developmental activities of Lakoti village does not suffer for want of a full-fledged village council. With above observation, this writ petition is hereby disposed of.
For judgment, item number 21.
In WPC number 142 of 21. In view of the judgment passed in WPC number 123/2021, and in view of the reasons mentioned in this judgment, the impugned selection and appointment of respondent number 5. Respondent number 5, who is a member against Ilang Khel of chairman as chairman of Lakoti village, and whose selection was also on the basis of the votes received by him from village council members, including Upper Khel, Haili Khel and Yantharo Khel and Petan Khel. And as the approval of village council member against the aforementioned khels have been suspended till the final decision from the government under section 20 of the Nagaland Village Council Act is received, the selection of respondent number 5 on the basis of said votes may not be sustained and therefore is liable to be set aside. And accordingly, same is set aside. However, as the suspension order dated 10 June 2021 in respect of village council members of other four khels of Lakuti village has been revoked. The village council members of the said khel may choose a chairman amongst them to be the chairman of Lakuti village in pursuant of section 7 of the Nagaland Village Council Act till a final decision in this regards is taken by the government under section 20 of the Nagaland Village Council Act. With above observation, this writ petition is hereby disposed of.
For judgment, item number 21.
For reasons mentioned in the judgment, this writ petition is dismissed on the ground of delay and laches by the petitioner.
For judgment, item number 22.
For the reasons mentioned in the judgment, the state respondents are hereby directed to consider the representation of the present petitioner for grant of minimum scale of pay to him like that of other similarly situated work charge employees to whom minimum scale of pay has been granted within a period of 3 months from the date of this order.
For motion, item number 1.
May I please, your lordship? This is an petition for quashing of a criminal proceeding under 482 of the CRPC. Initially, the petitioners, in the capacity of beneficiary under the Department of Tribal Affairs Nagaland, were allocated a project to construct a girls' hostel. Yes, your lordship. The amount was 1 crore. The project was completed as per the DPR, and the department had inspected the site as per the specification, and the work completion certificate was issued to the petitioners. And so the money, the fund was released to the petitioners. Now, the present respondent number 2 and 3 on misconception had filed a complaint against the present petitioners, saying that the fund has been misappropriated and the girls' hostel was never constructed. But the fact remains that the girls' hostel was constructed, but at present, none of the students showed interest to get themselves admitted into the hostel. So the place was lying vacant. So 2 rooms were used as classrooms for the government high school, composite high school, and the remaining rooms, sometimes they use it for public purposes, but the building is still constructed. So the case was filed on misconception. And after the filing of the case, there was a tense situation between the present respondent number 2 and 3, they are the complainants and the petitioners. So the public of that particular area, someone bought all of them, and it was clarified that the project was completed. So the respondent should withdraw the complaint case before the learned magistrate in Kohima here. So it was filed, and IA number 173 was filed by the respondent number 2, 3 for withdrawal of the complaint case, and it was dismissed, Your Lordship. So hence I'm approaching this court for the questioning of this criminal proceeding because
The respondent prayed for withdrawal.
yes, Your Lordship, they were the complainant in the trial court. Although the case was filed on the misconception, Your Lordship, the nature of the petition becomes a frivolous petition, Your Lordship, which is pending before the lower court. And as such, proceeding a jurisdiction under 482 has to be invoked by this honorable court.
Let us hear the respondent number 1 and 2.
2 and 3, respondent number 1 is the state.
Let us issue notice.
Yes, Lord.
Mr. I. Im Chen, learned counsel for the petition. This petition, criminal petition under 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners Lyayo Apon and Shri John Kath, praying for quashing of the criminal complaint case number 4/2023. There are 2 cases.
No, earlier it was registered as complaint case 4, and then it was converted to GR 80 of 2023.
It was converted in. Now it is not a complaint case.
Yes, it becomes a GR now.
Why it was referred? It was sent to police for investigation.
Yes, Lordship, and the investigation is pending as of now.
Which was forward, the complaint case number 4 oblique. Then there is no complaint case, then you have to pray for quashing of.
Yes,
your
I've
case.
prayed for that GR, yes, Lordship, in the relief. GR 80 of 2023.
What was the last one?
Praying for quashing of the criminal.
Praying
complaint
for
case.
quashing of GR case number 80/2023, which was registered on the basis of a complaint case number 4/2023, which was filed by respondent number 1 and respondent number 2 and 3 stuff. Learned counsel for the petitioner has submitted that respondent number 2 and 3 had filed an IA which was registered as IA number 173/2023 before the court of learned judicial magistrate. Which court?
Magistrate first class, Your Lordship,
Where?
in Kohima.
Judicial magistrate first class Kohima. Praying for withdrawal of the complaint case, however, same was not allowed by the order dated 28/9/2023 passed in IA number 173/23 and which is also impugned in the instant case. Issue notice to the respondents as Mr. K.V. Angami, learned public prosecutor, receives notice on behalf of respondent number 1. No formal notices need to be sent to the respondent number 1. However, as regards respondent number 2 and 3, the petitioner shall take steps for issuance of notice to respondent number 2 and 3 by registered post with ID.
Yes.
Within 3 days from date of this order, returnable after 3 weeks.
Sure. Your Lordship, there is an interim. The proceeding may be stayed before the trial court, Your Lordship.
After service of notice, the prayer for interim relief would be considered after service of notice on respondent number 2 and 3.
Much obliged, Your Lordship.
But we may continue.
For motion item number 2.
Yes, my lordship.
Yes. Oh, this is fixed at 2 p.m.
My lordship, am I audible?
Yes. As per cause list, this item is fixed at 2 p.m.
Yes, my lordship.
So let us take it up at 2 p.m. You are appearing for? Dr. Pang. Call it at 2 p.m. Otherwise, VC is also. We'll take it up at 2 p.m.
Obliged, my lordship.
For admission item number 10.
May please, Your Lordship. My lord, am I audible to your lordship?
Yes, yes.
My lord, by the last order dated 18/9/2023, in fact, the petition was admitted and matter was fixed for hearing today, but this has come on the admission column. If the court permits, I can continue with the hearing subject to the respondent for this similar.
Who is appearing for respondent side?
Please, Lordship, my senior, Lim Wapang is in court 1, Your Lordship, on his leg.
Now, are you ready for hearing today or we?
He's ready, Your Lordship. I just need 1 or 2 minutes, Your Lordship.
We'll take.
Yes, I can continue. Perhaps in the meantime, counsel may arrive.
No, let him come.
Lodge.
Item number 10, Mr. Who is appearing? Mr. Fonseca for,
Respondent, private
For-
respondent, Your Lordship.
is he there?
Yes. he was ready.
We'll take it up as next. Mr. Zimomi, are you ready for hearing?
Lordship, in that view of the matter, let it come after the vacation, Lordship, since the main respondent, the private respondent is not here today.
Who is appearing for private respondent?
Sir,
Lima Wapang, Lima.
No, but Mr. Vero said that he will be coming.
yeah, he's in court number 1. sir.
Let him come. We will take it up as next item.
Lodge.
We'll call it up as next item.
Lodge.
For orders, item number 11.
May I please, Lordship, Lordship, I've been instructed to appear on behalf of respondent number 8. So, Your Lordship, can you grant 3 weeks time to obtain the newly implemented respondent number 8?
Yes, who is appearing for petition?
Lordship, I'm for respondent number 1.
Who is for the petitioner?
I'm for the petitioner.
What is your name?
Arden Long.
Heard, Mr. Aaron Long. You have any objection to the prayer? No.
No, for hindering appearance, we have no objection. Whereas for other respondents, the service is still awaited.
Heard, Mr. Aaron Long, learned counsel for the petitioner. Also heard Ms. V. Sokre, learned additional AG, who submits that she has been instructed to appear on behalf of newly implemented respondent number 8. And she needs some time to seek necessary instructions. In this regard, the prayer is allowed. Also heard Mr. Nangami, senior government counsel, who appears for respondent number 1. Who else is appearing?
Lordship, I'm appearing for respondent number 2.
Mr.
I Jamir, Lordship.
I Jamir appears for respondent number 2. And Mr. Yangi
I have instruction to appear on behalf of respondent number 10.
appears for respondent number 10. Let the note, the against whom service report is awaited?
Yes, the note says that the service report is awaited for the other respondents,
For whom?
7 and 9,
7 and 9. Service is not yet complete.
completed but awaiting service report.
Okay. The service report against the notices issued to respondent number 7 and 9 is still awaited.
Yes, Lordship.
Let this matter be listed accordingly after 3 weeks.
Obliged.
For admission, item number 10.
May I please, the Lordship, Lordship, I see the CD, but without any supporting documents, Lordship. So if this matter can come up after the vacation, Lordship.
Okay.
No.
Yes, Mr. Soikia.
In that case, can it be convenient for the court to fix it on 20th November? Madam?
No, Lordship,
20th November.
Lordship.
Heard. Mr. P.J. Soikia. Learned counsel for the petitioner also heard Mr.
Lima Wapang, for
Lima
respondent number 2.
Wapang for Lima Wapang appearing for respondent number 2, as well as Mr. V. Zimomi, learned public prosecutor, appearing for respondent number 1.
Lordship.
Learned public prosecutor submits that though the case diary has been received in which was called for in connection with this case, however, it is not accompanied with the necessary supporting documents.
Lordship.
And on that ground, learned public prosecutor submits that this prays for an adjournment so as to obtain all the necessary supporting documents.
Lordship.
Considering the submissions made by learned counsel, learned public prosecutor, the prayer is allowed. Let this case be fixed again on which date you wanted? 6 November.
20th November. Madam,
On
20.
20th of November for hearing.
Yes,
For hearing.
For
For hearing. Well, the interim order passed earlier, may continue.
Against hearing column, the interim order passed earlier shall continue till next day.
Obliged.
For hearing, item numbers 12 to 14.
Lordship, petitioner is not present.
Oh, this is that CBM.
Yes, yes, the transfer, yes, that is what he is asking, Lordship, yes.
He might not have been expecting that it would be called.
Yeah,
for.
might be,
So let us wait for him,
Lordship,
wait for some time.
Lordship.
This 15, 16, 17, though it is fixed at 2, it may be called up now.
Okay.
The lawyer,
For hearing, item number 15 to 17.
who is for the respondent side? You are ready? Okay. Yes, it may be called. Yes.
May it please your lordship.
Yes,
These, all the three petitions are for different assessment years. Otherwise, the issue is common.
yes.
For the assessment year, first petition is for the assessment year 2014-15.
Now what is we are taking up petition number 155.
Well, first petition also may take up 155.
Yes,
Well, the assessment of the petitioner for the assessment year 2014-15
yes,
was completed on 19/1/2015.
19/1/2015.
19/1/2015. After due examination of the books of accounts and documents, and you'll also find the assessment orders at page 29 and 33.
Yes,
The 29 million, the assessment is under Assam, Nagaland Sales of Petroleum and Petroleum Products, including Motor Speeds Act, and at page 33 is the Central Sales Tax Act.
this is assessment of which?
Well, assessment for the period 2014-15.
Okay,
Assessment year 2014-15. Well, after the completion of the assessment, after due examination of the books of accounts and documents below, a notice was served to the petitioner on 28/4/2020.
okay,
Purportedly, my lord, under section 20 of the Nagaland Sales of Petroleum Act, which you'll also find at page 36.
Nagaland Sales of Petroleum Act
Petroleum Act, my lord.
at page
36.
This is notice under section 20 of the.
20 of the Nagaland Petroleum Act, my lord.
Taxation Act 1967. Yes,
Section 20 of the Nagaland Petroleum Act, my lord, provides for a suo motu revision. Power has been conferred on the commissioner for suo motu revision.
yes.
Now, my lord,
Albert, whether
at that time, the period was the COVID period, my lord.
Nagaland Sales of Petroleum Taxation. Yes, so motor revision.
My lord. Shall I place the section first, my lord? Section 21, my lord.
Section 21,
My 20 subsection 1.
clause 1. Yes,
May I read, my lord? Section 21, my lord.
the commissioner may call for and examine the records of any proceeding under this act, and if he considers that any order passed therein by any person appointed under section 5 to assist him is erroneous insofar as is prejudicial to the interest of revenue, he may, after giving the dealer an opportunity of being heard, and after making or causing to be made such inquiry as he deems necessary, pass such order thereon as the circumstances of the case justify, including an order enhancing or modifying the assessment and directing a fresh assessment.
Okay. Yes.
So, my lord, if the commissioner, after calling for the records of the case, is of the opinion that any order passed by an authority appointed to assist him is erroneous insofar as the same is prejudicial to the interest of revenue, then he may, after giving the dealer an opportunity of hearing, pass such orders, either enhancing or modifying the assessment or directing a fresh assessment.
Okay.
So the precondition is that, my lord, that the commissioner must be of the opinion that the order is erroneous insofar as the same is prejudicial to the interest of revenue.
He must come to this finding that it is erroneous and prejudicial.
My lord.
Okay.
And I will take your lordship to the various pronouncement that what is erroneous and what is the meaning of the, and under what circumstances the commissioner can invoke such powers, but that will be only after placing the order of the commissioner, my lord.
Erroneous and prejudicial to
The interest of revenue. That means, my lord, for being erroneous, prejudice has been caused to the interest of the revenue. First of all, it must be erroneous, my lord, and then prejudice must be caused to the revenue.
Okay.
Now, your lordship may kindly see, my lord, page 36.
Yes.
It was a notice for revision under section 20 of the Nagaland Sales of Petroleum Act 1967. Now, the commissioner, in fact, directed the dealer to produce various documents and papers for the assessment years. Now, your lordship may see, whereas despite notice followed by reminder notices, including the last notice served on you in your official data so and so, you have not fully complied with the terms of the notice till date. Now it appears to me, beyond reasonable doubt, that you are willing and deliberately ignoring to comply with the terms of the notices and thereby defaulted and liable to necessary action, appropriate actions under the Act and rules. Whereas cross verification of the statement produced so far before the court with records filed by you during the assessment proceedings reveals the following inconsistencies. Now we'll also kindly see the bottom below. You see 11, 12, we may come to 14, 15 below. At page 38 below.
Yes. Yes.
Text period 14, 15 below. Statutory form statement shows.
No, where are page 38?
38 below.
Tax period for 2014-15.
14, 15 below.
Yes.
It says below, statutory form statement shows that there was purchase of LPG worth rupees so and so during the period. However, the sales figures as per the AOs excluding tax shows to be rupees so and so only. A statutory form statement shows that there was a purchase of MS and HSD worth rupees so and so during the period. However, the sales figures as per the AO assessment orders, excluding tax, shows to be so and so, showing an excess declaration by rupees so and so. Trading account was not made available before this state court till date, nor filed at the time of assessment. Purchase records of SKD was not made available to this court for scrutiny despite several notices. No evidence of record or transactions affected to other OMC was disclosed. Cross-examination of transaction records between IOC and for the period reveals the following inconsistency in figures. You also make a note, Miller, that it says that the figures, there was a inconsistencies. Now the inconsistency in the table, it has been pointed out. Thereafter said, Miller, you are therefore once again called upon to appear in person or through representative duly authorized by you in writing before me on the date and time given below in my office chamber, and to further so cause in writing and with all supporting documents as to why the return filed by you for the period so and so should not be rejected as incorrect and incomplete. You know, and necessary action, including the order under section 20 of the Sales of Petroleum Act, should not be passed against you. So the commissioner called for certain documents and papers from the dealer to show cause that it appears that there are some certain inconsistencies in the documents and papers which were submitted at the time of assessment order, and thereby why the action should not be taken against the SSC or under section 20 of the Act. Now, we'll also see page 39.
Yes.
This was the order passed under section 20 of the Act. I may read, Miller. This is the important one.
What is this?
This is the final order passed of geometry revision under section 20 of the Act.
Yes.
I say, Miller. So and so is a registered firm in the state under the Nagaland so and so Act and Central Sales Tax Act 1956, and is a prominent regular taxpayer in the state. The firm deals in high-speed diesel and so item so and so. An exercise of the power delegated to me by notification number so and so, the proceeding records of the IOC so and so were called for examination. On examination of the proceeding records, it observed that the assessment order passed by the learned supreme taxes for the assessment is so and so as erroneous insofar as it is prejudicial interest of revenue and requires further inquiry and verification. And requires further inquiry and verifications and pass necessary order under section 20 of the Act. So the commissioner says that according to him, the order was erroneous and prejudicial to the interest of revenue, and thereby the same requires further inquiry and verification.
Yes.
Now we'll also see. Therefore, in order to ascertain that the firm has filed a complete and accurate return with all the supporting documents and statements and pays proper tax regularly, a notice for revision under section 20 was issued on so and so for the assessment year so and so to appear in person through an authorized representative before the sign so and to furnish details of the year-wise utilization of the statutory forms, etc. Now, Lord see, my lord, that the commissioner is saying that what was the purpose of issuing the section 20 notice? The commissioner says that in order to ascertain that the firm has filed complete and accurate returns with all supporting documents and statements and paid proper tax regularly. Now, with this purpose, the notice under section 20 was issued.
Okay.
Now, Lordship, can you see, Lord? It says, details of the year-wise sales made to the outside the state of Nagaland in form so-and-so, consolidated year-wise transaction details with the state in so-and-so, and other documents as may be necessary to rely upon in support of the returns filed for further verification. So the commissioner initiated the proceedings under section 20 of the Act, directing the dealer to produce various statements and documents for further verification with the object to ascertain whether the dealer has filed the complete and accurate returns and has paid complete tax thereon or not. This was the purpose for which section 20 notice was issued to the petitioner, which the commissioner himself is recording in his order. Now, Lordship, can you see, Lord? A reminder notice was issued on so-and-so and was delivered on the same day by the inspector of taxes so-and-so. The notice was personally delivered on so-and-so to so-and-so, and however, the firm failed again to comply with the without assigning a revision. Further reminder notice was issued with the complete failed to comply. In order to afford reasonable opportunity to comply with the notice, a last reminder was issued on so-and-so, returnable so-and-so, failing which necessary proceeding, including prosecution, shall be initiated with the firm under the Act without any further reference to them. The notice was delivered and received on behalf of the firm on so-and-so. Sri so-and-so assistant manager appeared on behalf of the IOC and submitted letter dated so-and-so, senior manager, containing the para-wise reply to the notice dated so-and-so. The same was filed for record. On examination of the para-wise replies, it was found that the information sought in Form 3 was furnished partially and many inconsistencies were observed. Thereafter, so-and-so was asked to furnish the information in full without any further delay. He was asked to furnish the soft copies of the information produced before this court through email, and hearing was adjourned to further notice. The soft copies of the required information sought to inform so-and-so were received through email on so-and-so. Since complete information in so-and-so was not furnished, a notice was served through email in so-and-so to furnish the remaining information in form so-and-so, including year-wise and commodities-wise purchase and sales details in format so-and-so account, and any other details the firm wished to produce in support of the returns filed on 14/11/2019. So the commissioner was in fact directing the dealer to produce the documents and papers in support of its return. Now, Lordship, can you see? However, the SSC failed to respond to the notice dated so-and-so. Therefore, preliminary inconsistency observed on the records available in the proceeding files and the information already produced before this court so far were notified to the firm by way of notice dated so-and-so, along with the to appear person and through representative duly authorized by him in the writing so-and-so for the tax period so-and-so, and on so-and-so for the tax period so-and-so, and to further show cause in writing with all supporting documents as to why the return filed for the tax periods, as to why the return filed for the tax periods should not be rejected, and as incorrect and incomplete, and failing which necessary action, including an order of revision under section 20 of the Act, shall be passed against the firm without any further reference to the SSC. So, the so-called was issued that in case you don't comply, you don't furnish the informations, the return filed by the dealers shall be rejected, and necessary action under section 20 will be taken. Now, the said notice was emailed to the so-and-so and also delivered to one official under Dimapur so-and-so. On so-and-so, the undersigned received a letter on behalf of so-and-so finance manager, but requesting 60 days time for compilation and submission of the requisite data, as the same was already under process and is expected to be complete within an extended period. In order to afford all reasonable opportunity to the firm to comply with the terms of the notice, the extension of time for 60 days was considered and allowed and notified to the firm by way of notice dated so-and-so, and the next date was fixed on so-and-so for the tax period so-and-so for the tax period so-and-so. However, the SSC has again failed to comply with the terms of the notice till date. Despite all sincere efforts by this court to enable the firm to comply with the terms of the notice, the firm ultimately failed to comply without assigning in lawful reasons. Now it appears to me beyond a reasonable doubt that the firm is willfully and deliberately ignoring to cooperate and comply with them there is no point of issuing further notice to them than to complete the revision in the interest of revenue. Therefore, considering the facts and circumstances of the case and in the interest of revenue, revision order is passed in section 21 of the Act, and the assessment order dated so-and-so passed by the learned superintendent taxes for tax haven is revised, and turnover escaping assessment, you'll also see, turnover escaped assessment and short payment of tax payable is determined as under.
Turnover escaped assessment and short payment of taxes. Okay. Yes.
So, my lord, I will not take it or see that below one because he's making the assessment that I'll come to later on, my lord. So, from this order, your lordship will note 3-4 things, my lord. One, the so-called notice was issued to ascertain as to whether the dealer has submitted all the requisite papers and documents in support of the return, and whether full payment of tax was made or not. Secondly, the commissioner says that in case you don't appear, then the return submitted by you would be rejected.
Yes.
And orders shall be passed under section 20 of the Act, that is for suo motu revision. Now the commissioner further says that the order is erroneous and prejudicial interest of revenue and requires further inquiry and verification. So he says the language that the order is erroneous and prejudicial interest of revenue and requires further inquiry and verification. And you'll also further see that it says that the turnover has escaped assessment.
What it means?
And
Turnover escaped assessment.
my lord, escaped assessment, there are different terminology and different powers are there under the Act. My lord. Like in the case after the assessment is completed, the assessing officer finds that certain turnover had not been taxed.
Okay.
Then turnover is escaped assessment.
For that, again, assessment is made, has to be made.
That notice will be issued for reopening the assessment
Okay.
and again completing the fresh assessment. So, my lord, I will come to that to show you, Lordship, my lord, that there are different powers have been conferred on different authorities to be exercised in different situations. One is, my lord, the rectification of the mistake. If there is some mistake is committed, then that can be rectified, and that power is conferred on the assessing officer. The second is, my lord, escapement of the turnover. If the turnover has escaped assessment, there is separate power conferred under the Act, and that power has been conferred on the assessing officer, who can issue notice to the assessee, and that is subject to various conditions and restrictions.
Okay.
Now, this third is the power of suo motu revision when the order is erroneous and
This power under section 20 of suo motu revision
my lord,
is with which authority?
is the commissioner, my lord,
Commissioner. Okay.
commissioner of taxes.
In the instant case, he has exercised the power and assessed and again assessed the tax, which is to be
My
paid.
lord. My lord.
Okay, okay.
He himself has made the assessment and completed the assessment also, and determined the tax what is to be payable.
Okay, okay.
Now, my lord, the Supreme Court is very, I will place before your lordship the judgments that the different powers which have been conferred under the Act, like for rectification, the turnover escaping assessment, and suo motu revision, are to operate in different fields. One authority cannot take the powers of another authority, which is reserved for another authority in separate conditions. Now, in this case, you'll also clearly find that the commissioner, first of all, says that it needs further inquiry and verification.
Yes.
So by that time, my lord, the commissioner was not sure that whether the order is erroneous or prejudicial to the interest of revenue, because he says it needs further inquiry and verification. Secondly, my lord,
So your submission is that before coming to a finding that the assessment is erroneous, that
My
the
lord.
inquiry and verification ought to have been completed first.
My lord,
And then he should have come to this finding that is it erroneous and
absolutely correct, my lord. Without coming to the conclusion, only quoting the language that it is erroneous, because he says that it needs further verification and the inquiry. So he has not come to the conclusion that the order is erroneous and prejudicial to interest of revenue.
okay.
Secondly, my lord,
Yes.
the commissioner is saying, in case you don't file the documents, papers, etc., your returns shall be rejected. Now, you'll also find section 20 of the Act. It says, if any order passed by any authority appointed to assist him is erroneous and prejudicial to interest of revenue. Now, the return which is submitted by the SSC is not an order which is passed by any authority. The return is a return submitted by the SSC.
So he has to find out error in the
Order.
Orders passed by person appointed under section 5 to assist.
My lord. There
Not-
must be an order in the error in the order passed,
Okay, not in the assessment file.
not in the returns file, my lord.
Returns filed by the.
My lord. Not in the return file. You cannot say that your return file were wrong, so I will reject it. That power has not been conferred by section 20 of the Act.
So some other authority has been bestowed with those powers, perhaps.
That is for reassessment. If somebody finds that there is escapement of turnover, then the assessing officer has the power.
Okay.
And which the Supreme Court has laid down that these different powers are there, which are to operate in different fields. And one authority cannot trench upon the powers which are reserved for some other authorities. Now, thirdly, my lord, your lordship has seen in section 20 that the commissioner may call for the records of the case.
Yes.
And if you find that an order is erroneous and prejudicial in nature of revenue.
Yes.
The commissioner cannot, my lord, call for the records from me, my papers and documents, for arriving at the conclusion that any order is erroneous. That is not permissible in section 20 of the Act. Section 20 of the Act, the commissioner must come to the conclusion on the basis of the records which are there. He must call for the records. And if he finds that any order is erroneous, then he may pass any order.
Which records? Records
Of the assessment, my lord, that is maintained by the department. My lord, records, call for the records. Your mechanism, my lord, calling for the documents and papers from me are not records.
Okay.
When we say, my lord, the records of the case,
It is
then
from
the
some authority. Some
my
other-
lord. My lord, the records of the case means which is maintained by the office.
Some other authority under the Act.
My lord. If the records of the case also will mean, my lord, the documents and papers which I will be asked to submit. No बेटी दिखाइए से भाई कि तुम्हारे के absolutely bogus. I am sorry, my lord. I am sorry, my lord. ये दोनों charges है ना. So, my lord, the records of my lord. My lord, am I audible, my lord?
Oh, there are, now it is okay.
My lord. अरे भाई की हो जाता है तो समझ में नहीं.
Yes, yes.
तुम्हारे की- My lord, can I also hear me, my lord?
Yes.
My lord. My lord, if the course of the case means that the documents and papers to be called for from the SSC, then it will amount to, my lord, re-examination of the documents and papers. For the purpose of exercise of powers under section 20 of the Act.
Yes.
Which is not permissible.
Okay.
And lastly, my lord, I'll come to that, my lord. Your lordship has seen that the power of making assessment is with the assessing authority. And in section 20, your lordship will find that he may direct for making a fresh assessment. As your lordship got it, not in section 20,
Yes, 20 clause 1, last line.
last line, direct making of the fresh assessment.
Yes.
The section 20 does not confer any power on the commissioner to make the fresh assessment himself.
Who is to make this fresh assessment?
Well, the assessing authority, the Supreme Taxes.
Assessing authority is the superintendent of taxes.
My lord, my lord.
Okay.
Now that order, the commissioner is examining. And if the commissioner finds that that order is erroneous and prejudicial in interest of revenue, then the commissioner may enhance, may modify, or direct for making a fresh assessment.
Who are the persons who may be appointed under section 5?
Well, there are various persons like the assistant commissioner, commissioner, Supreme Taxes, the Supreme Taxes, inspector.
Including the superintendent of taxes.
My lord, my lord, my lord.
And your submission is that the appropriate authority would be superintendent of taxes to
My
assess.
lord, my lord.
Okay.
This is my lord, the last submission which I am making, but my main submission is that the order which has been passed by the commissioner is illegal and without jurisdiction. But this is a last submission which I am making, that in any case, the order is illegal because the commissioner has no power to enter into the shoes of the assessing authority and make the assessment himself.
Your submission, what I understand,
My lord.
is that he cannot himself assess the returns.
My lord.
He can only verify the orders passed by his subordinate authorities.
My lord. Absolutely correct, my lord.
Whether the orders needs some rectification or not.
My lord, in other words, my lord, I say that whether the order is erroneous in his interest of
But the other orders of his subordinates,
my lord.
the powers under section 20, according to your submission, is with the commissioner only to assess the error in the orders passed by his subordinates.
My lord, absolutely correct.
Okay, okay.
Now, these are the short facts, my lord. Now, I will take your lordship directly to the law on the subject.
Yes.
But I have given a compilation.
And compilation is given.
Marking করে দিছ? এখানে আছে, কি আছে? এই আছে, রাজেন্দ্র স্যার। ছোট আছে।
Yes.
My lordship may kindly see what decision division bench of the Gauhati High Court, which your lordship find page 24. My lord, this was a matter under the Tripura Sales Tax Act, and lordship find the section at page 30.
Yes. Revision by commissioner.
My lord, the commissioner may call for and examine the records of the proceeding under this act, and if he considers that any order passed therein by any person appointed under subsection 1 of section 4 to assist him is erroneous insofar as it is prejudicial to the interest of revenue. He may, after giving the legal opportunity being heard, and after making or causing to make such inquiry as he deems necessary, pass such order thereon as the circumstance justifies, so and so, so and so. So this is parametry, my lord, to section 20 of the Budget Act, my lord. Now we'll also see para 7 on the same page, my lord.
Yes.
From a reading of subsection 1 of section 21, it is clear that the power of suo motu revision can be exercised by the commissioner only if, on examination of the records of any proceeding under the Act, he considers that any order passed therein by any person appointed to assist him is erroneous insofar as it is prejudicial to the interest of revenue. It is therefore not an arbitrary and unchartered power. It can be exercised only on fulfillment of the requirements laid down under subsection 1. The consideration of the commissioner as to whether an order is erroneous insofar as it is prejudicial interest of revenue must be based on materials available on record of the proceedings called for by him. Your Lordship, may kindly note, my lord.
Yes.
If there are no materials on record on the basis of which it can be said that the commissioner acting in a reasonable manner could have come to a conclusion, the very initiation of proceedings by him will be illegal and without jurisdiction. The commissioner cannot initiate proceedings with a view to starting fishing and roving inquiries in matters or orders which are already concluded. Such actions will be against the well-settled policy of law that there must be some point of finality in the legal proceedings, that stale issues should not be reactivated beyond a particular stage, and that lapse of time must induce repose in and set at rest judicial and quasi-judicial controversies as it may other spheres of the human activities. Now we'll also see para 9 below.
Yes.
The power of the suo motu revision under subsection 1 is in the nature of supervisory jurisdiction, and the same can be exercised only if the circumstances specified therein exist. Two circumstances must exist to enable the commissioner to exercise power of suo motu revision under this subsection. 1, the order is erroneous. Number 2, by virtue of the order being erroneous, prejudice has been caused to the interest of revenue. It is not sufficient that the order is erroneous. It must be erroneous and also prejudicial to the interest of revenue. If an order is erroneous but not prejudicial to revenue, the commissioner cannot exercise power under this subsection. Likewise, it is not sufficient in exercising the power under section 21 that the order in question is prejudicial to the interest of revenue. It must be erroneous first, and if it is so, then it can be revised insofar as it is prejudicial to the interest of revenue. It has therefore been considered finally, firstly, as to when an order can be said to be an erroneous. We find the expression erroneous, erroneous assessment, and erroneous judgment have been defined in Black's Law Dictionary. According to definitions, erroneous means involving error, deviating from law. Erroneous assessment refers to an assessment that deviates from the law and is therefore invalid and is a defect that is jurisdictional in nature and does not refer to the judgment of the assessing officer in fixing the amount of the valuation of the property. Similarly, erroneous judgment means one rendered according to course and practice of the court, but contrary to law, upon mistaken view of law or upon erroneous application of the legal principles. From the aforesaid definitions, it is clear that an order cannot be termed as erroneous unless it is not in accordance with law. If an officer acting in accordance with law makes certain assessments and determines the turnover of a dealer, the same cannot be branded as erroneous by the commissioner simply because, according to him, the order should have been written more elaborately. This section does not visualize a case of substitution of the judgment of the commissioner for that of the officer who passed the order, unless the decision of the subordinate officer is held to be erroneous. Cases may be visualized where the assessing officer, while making an assessment, examines the accounts, makes inquiries, applies his mind to the facts and circumstances of the case, and determines the turnover, either by accepting the accounts or by making some estimates himself. The commissioner, on perusal of the records, may be of the opinion that the estimate made by the officer concerned was on the lower side and left to the commissioner, he would have estimated the turnover at a higher figure than determined by the assessing officer. That would not vest the commissioner with the power to re-examine the accounts and determine the turnover himself at a higher figure. You also kindly mark the word re-examine the accounts. It is because the officer exercised the quasi-judicial power vested in him in accordance with law and arrived at a conclusion, and such a conclusion cannot be termed to be erroneous simply because the commissioner does not feel satisfied with the conclusion. It may be said in such a case that the opinion of the commissioner, the order in question, is prejudicial in the interest of revenue, but that by itself will not be enough to vest the commissioner with the power of revision, because the first requirement, namely that the order is erroneous, is absent. Similarly, if an order is erroneous but not prejudicial interest of revenue, then also the power of suo motu revision cannot be exercised. Any and every erroneous order cannot be subject matter of revision because the second requirement must also be fulfilled. There must be some prima facie material record to show that the tax which was lawfully exigible has not been imposed, or that the application of the relevant statute or incorrect or incomplete interpretation of a lesser tax than what was then imposed. Now, just you may see para 12 below. We further hold that in order to exercise power in the subsection 1 of section 21 of the Act, there must be material before the commissioner to consider that the order passed by the officer was erroneous insofar as it is prejudicial interest of revenue. We have already held what is erroneous. It must be an order which is not in accordance with law or which has been passed by an authority without making an inquiry in undue haste. We have also held that what is prejudicial interest of revenue, an order can be said to be prejudicial interest of revenue if it is not in accordance with law, in consequence wherefore lawful revenue due to the state has not been realized or cannot be realized. There must be material available in record called for by the commissioner to satisfy him prima facie that the aforesaid two requirements are present. If not, he has no authority to initiate proceedings for revision. So, my lord, in the records called for by him, from him, that he must come to the conclusion. Exercise of the suo motu power under circumstances will amount to arbitrary exercise of powers. It is well settled that when exercise of the statutory power is dependent upon existence of certain objective facts, the authority before exercising such power must have materials on records to satisfy it in that regard. If the action of the authority is challenged before the court, it would be open for the court to examine whether the relevant objective factors are available from the records called for and examined by such authority. Our aforesaid conclusion gets full support from the decision of the so-and-so. In our opinion, any other view of the matter will amount to giving unbridled and arbitrary power to the revision authority to initiate proceeding for revision in every case and start re-examination and fresh inquiries in the matters which have already been concluded under the law. As already stated, it is a quasi-judicial power held by limitation and has to be exercised subject to the same and within the scope and ambit of ambit so far as calling for the records and examining the same is concerned. Undoubtedly, it is an administrative act, but no examination to consider or to other words to form an opinion that the particular order is erroneous insofar as it prejudices the interest of revenue, a quasi-judicial act, because on this consideration or opinion, the whole machinery or re-examination and reconsideration of order assessment, which has already been concluded and set at rest, is set in motion. It is an important decision, and the same cannot be based on the whims and caprice of the revision authority. There must be materials available from record called for by the commissioner. We have examined the facts of the present case in the light of the aforesaid legal position. On perusal of the affidavit and records, it appears that there was no material to show that the superintendent taxes who made the assessment did not make requisite inquiries or did not examine the requisite records. On the other hand, it is evident from the assessment order itself, the petitioner produced all the relevant books of accounts, including daily sales register, consolidated the monthly statements, so and so, and the same were examined by the assessing officer, and in consideration of the same, the assessment was made. The commissioner has also does not dispute this position. It is not a case where no inquiries were made by the assessing officer or the assessment was made in undue haste without the inquiries. The grievance of the commissioner is that the assessing officer, namely superintendent, did not elaborate in his order discussion on the books that he had examined and the basis of his satisfaction, and stated in order notice itself that he expected the assessing officer to mention the reconciliation that had been obtained after scrutiny of the records relating to the payment of wages, consumption of the fuel, production of the bricks, etc., etc. So, from this judgment of division bench of this on the court below, the Tripura bench, two things are very clear, Miller, that the satisfaction of the commissioner must be from the records called for from him,
Yes.
and not from making further inquiries and the calling for the documents. Secondly,
In the instant case, he is calling for the documents directly from the SSC.
my lord,
Okay.
and he is saying, my lord, that further inquiries and all these things are required to ascertain whether the return which was submitted by the SSC, all documents and papers were filed, and whether the full payment of the tax due was made or not.
Okay.
So the commissioner has, from the records, has not come to the conclusion that no, full tax was not paid. The commissioner has not come to the conclusion that no, the documents and papers etc. were not there, and thereby the order is erroneous. He is making a re-verification of the assessment proceedings.
Which is barred according to.
Which is not permissible, my lord, under section 20 of the act.
He has to only find out error in the order of his subordinate.
My lord, and from the materials which are available in the records which are called for by him.
Okay.
Not by calling for the documents from me to say that I will find out and re-verify your documents to find out whether you have paid the correct tax or not, or whether the full documents and papers were submitted at the time of assessment or not. That is outside the scope of section 20 of the act.
Okay.
Now, this judgment, division bench judgment of this honorable court, there was another division bench judgment of this honorable court, and the court felt that the matter should be referred to a larger bench to determine whether there is a conflict in the judgment of which I placed before Lordship and another judgment, and Lordship find the full bench judgment at page 48.
Yes.
Now, in the full bench judgment, my lord, the full bench came to the conclusion that there was no conflict between the judgment which I placed before Lordship and the another judgment which was delivered by the another division bench of this Honorable Court. I will take your Lordship to the 11th paragraph. Your Lordship may see paragraph 18 at page 59. Paragraph 18 below.
Yes.
In the above judgments, exercise of the revisional powers was held to be limited to the jurisdictional error as against jurisdiction to substitute opinion of the revisional authority for the opinion of the primary authority without excluding interference where there was wrong or illegal exercise of jurisdiction. Expression jurisdictional error cannot be understood in a narrow sense. We may now refer to so-and-so, wherein the assessing officer did not make inquiry with regard to the appraisal report available with him on the basis of such conducted, showing that the assessee was providing accommodation entries. On this ground, the CIT exercised the supreme power under section 263, which was held to be not permissible on the ground that the CIT had not discussed contents of the appraisal report. On further appeal to this court, the assessee supported the order of the tribunal by submitting that exercise of the supreme revisional power by the CIT was not permissible in absence of a jurisdictional error in the order of the assessing officer as held by his court in so and so. This court held that if the order of the assessing officer was passed ignoring relevant materials causing prejudice to interest of revenue, suo motu revisional power could be exercised by the CIT even if it could be held that there was no jurisdictional error in the order of the assessing officer. The observations of the court are as under. You also may skip over para 20 below. For reaching the above conclusion, this court referred to the judgments of the Honorable Supreme Court in so and so and so and so. And I will take your lordship to directly to the relevant part, para 72 will. Para 22 at page 61.
Yes.
We have already referred to the judgments of this court in Rajendra Singh, which I placed before your lordship, and two single bench judgments following the said judgment in the Bangaigaon refinery and so and so, and the division bench judgment in Daga so and so. No doubt in Rajendra Singh, an observation was made that erroneous assessment referred to the defect which is jurisdictional in nature as against substitution of one's view for that of the other merely on the ground that a different view was possible. If read as a whole, the judgment does not exclude error of assessment order by ignoring relevant material, not holding such inquiry as is normal and not applying mind is relevant material would certainly be erroneous assessment warranting exercise of the jurisdiction. Judgment has to be read as a whole and an observation during the course of the reasoning of the judgment should not be diverse from the context in which it was used. The judgment is neither to be interpreted as an act of parliament nor a holy book. If this principle is kept in mind, we do not find any conflict in the view taken by the Rajendra Singh and so and so. Disagreement in so is only to the interpretation which limits the ratio of the judgment by relying the one sentence in isolation, diverse from the entire judgment, an incorrect assumption of the facts or an incorrect application of the law will satisfy the requirements of the order being erroneous, non-application of mind, and omission to follow natural justice in the same category. So, my lord, ultimately the court said, my lord, that
in Dhaga and Trade Private Limited, what different view was taken?
my lord, they doubted that the words without jurisdiction.
Okay.
My lord, Rajendra Singh, it was said without jurisdiction, that the order is without jurisdiction. Now that has been explained here, you'll also see, my lord, the last 4 lines of para 22.
Yes.
Disagreement in data entered limited only to the interpretation which limits the ratio of the judgment by relying only on the sentence relation divorced from the entire judgment and incorrect assumption of the facts or incorrect application of law. So incorrect assumption of facts and incorrect application of law will satisfy the requirement of the erroneous assessment. So incorrect assumption of facts and incorrect application of law will also fall within the purview of the erroneous assessment
By the assessing authority.
by the assessing authority.
But
In the Rajendra Singh also it was said incorrect application of law, not in accordance with law, but there was one word without jurisdiction, jurisdictional error. And the court has clarified that jurisdictional error, it means wrong assumption of facts and the wrong application of law. And they said that there is no conflict between the 2 decisions of the court.
Okay.
Now I take your lordship to one decision of the Bombay High Court, which your lordship find at page 1. Now this was in the context of the Income Tax Act, Lord.
Yes.
Now it was below section 263, which you'll also find page 3.
Yes.
263 is quoted, Miller. It says the commissioner may call for and examine the record of any proceeding under this act, and if he considers that any order passed therein by an income tax officer is erroneous insofar as is prejudicial interest of revenue, he may, after giving the SSC an opportunity being heard, and so and so. So it is parameter, Miller, to section 20 and the Tripura 21 of the act. Now I will take directly to your lordship to para 13 at page 5.
Yes.
May I read, my lord? We therefore hold that in order to exercise power under section 1 of section 263 of the Act, there must be material before the commissioner to consider that the order passed by the income tax officer was erroneous insofar as it is prejudicial to the interest of revenue. We have already held what is erroneous. It must be an order not in accordance with law or which has been passed by an income tax officer without making an inquiry and undue haste. We have also held what is prejudicial to the interest of revenue. An order can be said to be prejudicial interest of revenue if it is not in accordance with law, in consequence whereof the lawful revenue due to the state has not been realized or cannot be realized. There must be material available on record called for by the commissioner to satisfy him prima facie that the aforesaid two requisites were present. If not, he has no authority to initiate proceedings for revision. Excise powers, sumotor revision under such circumstances will amount to arbitrary excise powers. It is well settled that when the exercise of restrictive power is dependent upon the existence of certain objective facts, the authority before exercising such power must have materials on the court to satisfy in that regard. If the action of the authority is challenged before the court, it would be open for the court to examine whether the relevant objective factors were available from the courts called for and examined by the such authority. Our aforesaid conclusion finds support from the decision of the so-and-so, Your Lordship may kindly skip over, my lord. And yes, my lord. In our opinion, Your Lordship will find after this year, in our opinion, any other view in the matter will amount to giving unbridled and arbitrary power to the revision authority to initiate proceeding for revision in every case and start re-examination and fresh inquiry to the matters which have already been concluded under the law. As already stated, it is a quasi power hedged with limitation and has to be exercised subject to the same and within the scope and ambit. So far as calling for the records and examining the same is concerned, undoubtedly it is administrative act, but on examination to consider, or in other words, to form an opinion that the particular order is erroneous insofar as the prejudicial interest of revenue is a quasi-judicial, and because on this consideration or opinion, the whole machinery of re-examination and reconsideration of an order of assessment which already been concluded and controversy which has been set at rest is set in motion. It is an important decision and the same cannot be based on the whims and caprice of the revision authority. There must be materials available from the records called for by the commissioner. Now next page below. Next page, para 14 below. You will see 5 or 6 lines from the bottom below. Further inquiry.
Yes.
As you also got it, no? Further inquiry and or fresh determination can be directed by the commissioner only after coming to the conclusion that the earlier finding of the income tax officer was erroneous and prejudicial to the interest of the revenue. Without doing so, he does not get the power to set aside the assessment. In the instant commissioner case, the commissioner did so, and is for this reason that the tribunal did not approve the action and set aside the order. We did not so. So, my lord, the first condition is that the commissioner must come to a conclusion, prima facie conclusion, that the order is erroneous and prejudicial to the interest of revenue. Now, further inquiry and fresh determination can only be after the commissioner arrives at such a conclusion.
He can himself make further inquiries,
He can make from the on the basis of records.
or he can call for additional document and supporting document from SSC directly.
Well, he cannot call for the additional documents to arrive at the conclusion. Well, after he comes to the conclusion on the basis of records,
Thereafter, he can ask.
thereafter he can call for and say that to make an inquiry. But for coming to that conclusion on the basis of the documents called for by him, it is not permissible,
That has to be on the basis of records available.
my lord, on the record,
On record.
my lord. Because this is not a case of re-verification of the documents papers. That is not the, my lord, the object of section 20 of the act. Section 20 of the act is of the supervisory nature,
That if some subordinate authority commits a wrong, that
my
will
lord.
be rectified.
Then if it is erroneous, then you can take steps. And erroneous has also been said, not in accordance with law. Now, your lordship may kindly see, my lord, the important judgment in the case of Amitabh Bachchan, which you'll also find page 7. And the relevant part is page 12. Charging question? Yeah, chair, kholu dekha jana. Para 7, para 9 at page 12 below. Here the court was examining the orders in the context of section 263 of the act. My lord. And you'll also see para 9 below at page 12. I will also see para 9. Under the act, that is income tax act law. Under the act, different sets of powers have been conferred on different authorities to deal with the orders of assessment passed by the primary authority. Section 147 confers power on the assessing officer itself to proceed against income escaping assessment. Section 154 of the Act empowers such authority to correct a mistake apparent on the face of the record. The power of appeal and revision is contained in Chapter 20 of the Act, which includes Section 63 that confers suo motu power of revision on the learned CIT.
Okay.
The different sets of the powers conferred on different authorities under the Act has to be exercised within the areas specifically delineated by the Act, and the exercise of power under one provision cannot trench upon the powers available under another provision of the Act.
Dr. Saraf,
My lord,
I am taking 2 minutes break.
my lord, my lord, my lord.
We'll join after 2 minutes.
My lord, my lord. More sound to work with. Sound to come on, sir.
Yes.
So, my lord, the apex court in the Amitabh Bachchan's case, my lord, held that there are different states of the powers conferred on different authorities which are to operate in different fields.
Now, whether in this Petroleum Act of Nagaland also,
My lord.
similar authorities are there to exercise.
Yes, my lord. Yes, my lord. I've given all the sections also in the petition. I will show to your lords, my lord. Same powers are there.
Similar to Income Tax Act.
Yes, my lord. I've
Okay.
given-
Okay.
Like the rectification, like, my lord, the for the purpose of escapement, the same powers are there, my lord. You'll also find I've given, my lord, in the page, my lord, 19 of the petition, my lord.
Okay. Page 19 of the petition.
page 19, paragraph 12 below.
Yes.
May I read below that paragraph?
No, okay, it is okay. I will go through.
My below, this is section 14 is turnover escaping assessment. Turnover 15 is Milord for rectification, and then Milord the different powers.
The other authorities are bestowed with exercise of those powers.
My lord.
Different authorities are there.
My lord, different authorities are there. Assessing authorities have been powered with the rectification, and well, like in the appeal, the rectification is there than the appellate authority. But in the case of well, the escapement of assessment, it is the assessing authority.
Okay. So the ratio of this Amitabh Bachchan's case is applicable to in this
My
case.
lord, in my humble submission, this is squarely applicable, my lord. Now, your lordship may kindly see a decision of the Madras High Court at page 20, my lord.
Yes.
And I will take your lordship to paragraph 9 at page 22.
Yes.
May I read, my lord? Page 22, para 9.
Yes.
We are also of the opinion that it is futile on the part of the commissioner to set aside the order of the income tax officer by directing him to consider the facts of donation of the distributorship business in favor of the SSC trust, when after considering the said fact, the conclusion that may be reached by the income tax officer would not be different. We therefore hold that the commissioner had no jurisdiction to set aside the order of assessment merely to conduct another purposeless and fruitless inquiry to reach the same result which was arrived at earlier. And if any fresh inquiry is held, it will be an empty formality, as by going through the motion of making the further inquiry and reaching the same conclusion, no useful purpose will be achieved. Though it is not expected of the commissioner to record his final conclusion in the order passed by the revision, he must at least indicate in his final conclusion in the order passed revision how the order of the income tax officer is erroneous and prejudicial to the interest of revenue. We therefore hold that the power of revision cannot be exercised as a matter of course, but it must be exercised to correct some error in the orders passed by the assessing authority. The revisional power is not meant to be exercised to correct every error of fact, but the error must be of such a nature that it is erroneous and prejudicial to the interest of revenue. We are of the view that the commissioner would have no jurisdiction to revise an order of assessment if the final conclusion arrived at by the commissioner could not be different. Then, after reconsidering the particular fact, the commissioner directed the income tax officer to consider. Further, the power of revision is not meant to be exercised for the purpose of directing the income tax officer to hold another investigation when the order of assessing officer was not found to be erroneous. If the Commissioner of Income Tax in the instant case, in our opinion, has merely set aside the order of income tax officer, directing the officer to hold further investigation without recording any finding that the order passed by the income tax officer was in any way erroneous and prejudicial interest of revenue, it was quite justified in holding that the order did not call for any interference in the revision done by the Commissioner of the Income Tax. Now here, my lord, the Commissioner himself is making further inquiries and investigations by calling for the records from me to find out as to whether I have submitted all the documents and papers in time of return and made the all payment of taxes which are due from me. That is not the power which has been conferred by section 21 of the Act. For 21 of the Act, the commissioner must come to the finding that the order which was passed by the assessing officer was not in accordance with law or was passed without making any inquiries or was passed in undue haste. The assessment order which is passed by the assessing officer in the state case is after examination of the books of accounts, evidence, documents, etc. It is not that the assessing authority can pass the order at its own. It is after due examination of the books of accounts and documents. So the commissioner cannot, in the use of the powers of show motor revision, start re-verification of the books of accounts, etc., and make the assessment himself. Which power had not been conferred by the Act on the Commissioner of Taxes. In the instant case, my lord, the commissioner having proceeded with the making of the inquiries, just like my lord, making the inquiry by the assessing officer, in my humble submission, the commissioner far exceeded the powers which have been, my lord, conferred on the commissioner by the Act, and thereby the impugned notice as well as the impugned order of revision passed by the commissioner in my humble submission is absolutely legal and without jurisdiction. This one judgment. Just give me 1 minute. Two separate judgments I've given, my lord. That is one of the Karnataka High Court, my lord. Jagannath Sethi.
In this compilation or
No, separately it was given, my lord. It was given separately.
Karnataka High Court.
Jagannath Sethi.
Separately put was.
The court junior.
Yes, Jagannath.
My lord. Your lordship may come to me, paragraph 5. It seems to us, it seems to us that the contention of so-and-so appears to be justified. There can be little doubt or dispute as to the relative jurisdiction of the Deputy Commissioner and the Assessing Authority under Section 21(2) and 12A of the Act respectively. While considering a similar provision under another enactment, the Supreme Court in so and so indicated the limitations to such revisional power is subject. I may read more. It would not invest the revising authority with power to launch upon inquiries at large, so as either to entrench upon the powers which are exclusively reserved by the Act or by the rules to the other authorities, or ignore the limitations inherent in the exercise of those powers. For instance, the power to reassess escape turnover is primarily vested in Rule 17 in the assessing officer and is to be exercised subject to certain limitations, and the revision authority will not be competent to make an inquiry to reassess a taxpayer. Now, Your Lordship, as seen in the order, the Commissioner was initially proceeding for escapement of the turnover.
Yes.
Now, that is outside the power and scope of Section 21 of the Act, 20 of the Act. This view has been reiterated by the Supreme Court in so and so. It is thus clear that the revisional power cannot be exercised in respect of the matter which falls within the power to reassess the escape turnover. The revision authority, in other words, should not trench upon the powers which are especially reserved to the assessing authority under Section 12A of the Act. The Deputy Commissioner in exercising the revisional power should not ignore these limitations. Now, thereafter, Your Lordship, there is yet another reason for not accepting the contention of so and so. Section 12A provides so and so assessment escaping turnover so and so. It is clear from these provisions that the reasons for turnover escaping assessment is immaterial. The turnover may escape assessment for any reason. It might be by oversight, mistake, or a design. If the record reveals no application of mind by the assessing authority in respect of the part of the turnover, then it must be deemed to have escaped assessment. It would therefore be a clear case falling within the exclusive jurisdiction of the assessing authority for reassessment, no matter whether that part of the turnover was in or outside the record of the assessment. If, on the other hand, the assessing authority has applied in mind and unwisely excluded any part of the turnover, then certainly it would be a case of revision to revise the assessment. The view we have taken finds support from the decisions of so and so. The view taken by the Madras High Court in full bench decision of so and so also lends support to our conclusion. While doing so, the scope of rules so and so are, which are somewhat similar to Rule 21 or 12A of the Madras High Court observed. So and so, in the light of these principles, since the assessing authority did not apply his mind to dispute turnover, the revision authority could not have invoked the powers of Section 21(2) of the Act.
In Petroleum Act,
My lord,
the authorities are prescribed for reassessing in case of escaped assessment.
my lord, your lordship, see, my lord, Section 14.
Section 14.
14.
Yes.
Your lordship, give 1 minute, my lord. 14, Your Excellency. It says, my lord, if upon information which has come to his possession, the commissioner is satisfied that any person registered under this act has not paid the amount of tax due from him or a part thereof for any period, he shall proceed against such person in a manner laid down in section 13. Now, section 13, Your Excellency. If upon information which has come to his possession, the commissioner is satisfied that the person, while being liable to pay tax under this act in respect to a period, has nevertheless willfully failed to apply for registration and pay the tax, he shall, after giving a person reasonable opportunity of being heard, assess to the best of his judgment the amount of tax, if any, due from such person of any period and all subsequent periods, and commissioner may also direct the addition to the amount so assessed, a sum not exceeding the amount shall be covered from the defaulter by way of penalty.
So it is the commissioner here.
But the power has been delegated to the assisting authorities. You'll also see the power, all powers are under the act of the commissioner. But he has, that power has to be delegated to the different authorities.
No, in the Karnataka judgment,
My lord,
which you have referred,
my lord.
was held that the power of assessment, which is reserved by the act on some other authority, cannot be taken over by the revising authority.
My lord.
So you have to show that power of reassessment in case of an escaped tax assessment is on
My lord.
some other authorities. It is not.
Your Lordship, may kindly see, my lord. I will show to your Lordship at page section 11.
Page?
Section 11, my lord.
Yes.
This is a power of assessment. Here, if the commissioner is satisfied that the return furnished in section 19 in respect of any period is correct and complete, he shall by an order, my lord.
In this act, it appears that every power is given to the commissioner.
My lord, the power in the act is delegated, all power is to the commissioner. But the commissioner, these powers of different powers have to be delegated to different authorities. Because, my lord, if the assessment is completed by the commissioner, there cannot be an appeal. You'll also see it pays section 19. The appeal.
Okay, but you have to show that this power of assessment.
So that I have showed to the lordship from the, after the other side start from the rules, it will be there that it has been delegated. Well, I will show to your lordship that it has been delegated.
But in case of Income Tax Act, it is the act which itself.
Milord, in the different acts, Milord, the normally, Milord, what happens? All the powers, the commissioner is appointed in the commissioner. You'll also see the appointment of the commissioner. The one commissioner is there. and the persons are there to assist him. The different authorities are there to assist him.
Section 5. No, your main submission was that this power is not vested on commissioner by the act.
My lord,
This power is vested on his subordinate authorities. And this is to be exercised by those authorities only.
my lord, absolutely, my lord. My lord, under the taxing statute, my lord, you'll also find section 5. If you'll also just take the section 5, my lord. The state government may, for carrying out the purpose of the act, appoint a commissioner of taxation and such other persons to assist him as he thinks fit. Persons appointed in subsequent ones shall exercise such powers as may be conferred and perform such duties as may be required by or under the act. And you'll also find in the present case also the earlier assessment was completed by the superintendent taxes only.
Oh, whether the Petroleum Act of Nagaland,
My lord,
the act where the powers are vested in different authorities,
my lord,
it does not appear to be such an act. It vests all powers on the commissioner and he has to be assisted by other his subordinates in performing the duties.
my lord,
Because the rulings which you have shown, which
my lord,
you are relying upon,
my lord,
it appears to me that in those cases, the act, the Income Tax Act or the TIPRA Act
my
vests
lord.
powers on different authorities.
But you'll also find the different authorities which are there. Now the commissioner, if the power is delegated to the same, in the present case, you'll also see the order of assessment, earlier order of assessment at page 30.
Yes.
It was by superintendent taxes. Now section 20, only when the persons, any order passed by the authority appointed to assist him is erroneous. It is a power which is to be exercised by the authorities appointed to assist him.
The main power is with commissioner.
Main power will under the act, there can be only one commissioner and different powers, authorities will be appointed to assist. You'll also see the rules. You'll also see rules, rule 3.
But in
You'll also see first rule 2.
Rule 2 is that
And the last part of the book will be the ML rules.
Rule 2, it is at page.
The book, it will be, I think, 26. Where I have taken the photocopy, my lord, of the book.
Yes, rule.
As you also got it, no? You'll also find the bottom, assistant commissioner has been defined. Then next page below. The super taxes 11 has been defined. And rule 3, taxing authorities. The state government may, in exercise of the powers conferred by section 5 of the Act, appoint by notification in the official gazette the following class of officers to the office of the commissioner. That is assistant commissioner, super taxes, inspector of taxes. Now, 4 below. Subject to the provisions of the Act and the rules framed thereunder, the commissioner may, by notification in the official gazette, delegate the powers to be exercised by the above classes of the officers and shall, by notification, specify the areas or the persons in respect of which the power are to be exercised by each of the above classes of the officers. That I think that the state will also not deny that the power is with the assessing authority, super taxes. Our Lordship may see section rule 19 below.
Provides for appeal.
An appeal against an order of assessment or penalty passed by the Supreme shall lie to the assistant commissioner.
So as there is a provision of appeal, it
My
implies
lord.
it is for the superintendent of taxes whose primary duty is to assess the.
My lord, because otherwise, if the commissioner passes the order, then he is the highest authority, there will no appeal, no revision. That's why section 20, it says by the appellate authority, and you'll also may also see, section 22, subsection 2. Section 20, subsection 2.
Yes.
In case of any order other than the order to which the subsection 1 applies, passed by any person appointed in subsection 5 to assist him, the commissioner may either of own motion or a petition by dealer for revision call for the records of the proceeding and the act in which such order has been passed, and may make such inquiry or cause such inquiry to be made, and subject to the act may pass such order thereon so and so. So a dealer may also file a revision application against any person appointed to assist him before the commissioner. Subsection 1 is the suo motu power, my lord, and subsection 2 is the revisional power.
In the
Now,
case,
my lord,
in the cases which are relied upon by you.
my lord,
There the statute itself gives power to various authorities.
My lord, in the earlier, in the like Assam Act, it was to the Commissioner of Taxes and it was delegated to all authorities,
Similar to the present act.
Present Act. Now, in the various act, my lord, the power is to the assessing authority, it is mentioned, prescribed authority mentioned, but the power are to the different authorities because to make the act workable, it cannot be that all the powers are to the commissioner. It cannot be. There is a one commissioner of taxes who is the head. And thereafter, there are persons to assist him. In all the act, you will also find that the authorities are appointed to assist the commissioner. Now, these authorities have been delegated the powers to perform different duties. And there are different limitations. Because, my lord, if the commissioner passes the assessment order, then there is section 21 will not be applicable at all.
Yes.
Neither section 22 will be applicable, nor appeal will be applicable.
But what is the situation in Income Tax Act?
Income Tax Act, you also find that the different authorities are there.
Statute itself prescribes.
Statute itself prescribes.
There is no delegation like.
Delegation are also there, but the statute itself provides that the order is to be passed. Like the section assessment is 143, my lord. Section 143 of the Act.
Where the assessing authority has been prescribed by the statute itself.
Well, I will just place before also, my lord. Section 143. This says, my lord, where a return has been made under section 139, so and so, and so and so. Thereafter, it says, my lord, such returns shall be processed in the following manner, namely, so and so, so and so, and 143.3. It says assessing officer.
Okay.
Even assuming, my lord, for the argument's sake, my lord, we take it as your lordship said, my lord, that either in the judgments it was the different authorities and in the commissioners. Now, argument's sake, I am saying, my lord, that all powers are with the commissioner only. Now, if all powers, assuming all powers are there for the commissioner also, then different provisions are there for different things. For escapement of turnover, different power.
So under section 20, okay, so under section 20, that power cannot be exercised.
My lord. One thing which falls in section 14, one cannot exercise the powers under section 20 of the Act. So, although, my lord, the power is with the assessing authority, but if you examine it from that light also, when different powers are there for different actions to be taken, then one cannot, under the use of the another power, exercise the powers of the another one, because, my lord, escapement of the turnover is 114. Now, assuming some order is erroneous and prejudicial interest of revenue, that will not be escapement of the turnover. One cannot exercise the powers in section 14. Like some order is erroneous, it cannot be rectification of mistake. Mistake is altogether different thing. So one cannot exercise the powers of rectification of mistake. Rectification of mistake is something apparent from the records. So one cannot say that the order is erroneous, so I exercise the rectification power. He cannot. So every power is to be exercised in different fields by the powers which have been conferred by the Act. Since section 21 of the Act gives the power to the commissioner to exercise when he comes to the conclusion that the order is erroneous and prejudicial interest of revenue. And thereby, the commissioner, on the basis of the materials available in the records, must come to the conclusion that the order is erroneous and prejudicial interest of revenue. Here, clearly, the commissioner is proceeding that there was escapement of the turnover. If it was an escapement of turnover, assuming, my lord, for the argument's sake, then the power which the commissioner has exercised is beyond section 21 of the Act.
Yes.
You know, see, seen below in the order, it clearly says for escapement.
Yes.
You know, see, just for my satisfaction, page 41.
Page.
Page 41, the third paragraph.
Turnover escaped assessment.
And the short payment of tax payable by so and so is determined as in the order is revised and the turnover escaped assessment. And what the commissioner is saying, you know, see me first again, although for the repetition also, at the first page of the order, my lord, at page 39.
Yes.
It says that call for the examination records proceeding, it observed that the assessment order passed by so and so are erroneous in so far it is prejudicial interest revenue and requires further inquiry and verification. How one can say that I will make an inquiry and thereafter come to the conclusion? And also, my lord, that I will come to the conclusion after verifying your records and reassess your turnover. Simply, my lord, using the words erroneous and prejudicial interest of revenue will not be sufficient. In fact, from the records, you have not come to the conclusion anything. Your lordship, again, once again, page 39, my lord. Although I submitted for lordship.
Yes.
The fourth paragraph, therefore, in order to, as your lordship, what in lord?
Yes.
Therefore, in order to ascertain that the firm has filed complete and accurate return and supporting documents and statement pays proper tax regularly, a notice of revision was issued. Can a section 21 notice can be issued to ascertain whether the firm has filed complete and accurate returns with supporting documents and a statement pays proper tax regularly. Whether this is the inquiry which is contemplated under section 20 of the Act.
This amount to reassessment.
This is making a fishing inquiry, my lord, not reassessment. For reassessment also, my lord, some information must come to the position of the assessing officer that any turnover has escaped assessment. Then only notice can be issued.
Okay.
No, my lord, if the new material is not there, reassessment notice cannot be issued. If, my lord, somebody is change of opinion, something on what's existing there, and he's examining again, reassessment cannot be done. Now, what the commissioner here is doing, he said that I will see that whether you have filed all the papers and documents or not, and whether you are paying the properly tax or not. What power is there with the commissioner, my lord, to make such a verification?
Under
Section 20.
Under 20, he has to come to a finding on the basis of available records.
And that finding must be there that the order is erroneous.
Yes, okay.
He has not come to a finding at all. He just want to ascertain whether you are paying the proper tax or not. How that power, my lord, can be exercised? So in my humble submission, my lord, the commissioner far exceeded the powers which have been conferred on him under section 21 of the Act. And further, by making the assessment himself, but that will be my secondary ground, my lord, that he cannot make the assessment himself. Assuming, my lord, he is making the assessment, where the appeal will lie. No appeal, no revision. He cannot make the assessment himself. He has not been given the power to make the assessment by section 21 of the Act.
In doing so, he has to be assisted by the other authorities.
But he has to direct for fresh assessment. He may set aside the assessment and may direct that fresh assessment may be completed in this way. But in this case, there is no question of a direction set aside, according to me, because the
direct fresh assessment by the
assessing authority,
appointed under section 5.
my lord. But in this case, in my humble submission, my lord, since the very first condition has not been fulfilled, the question of setting aside the assessment or making of the fresh assessment does not arise. And thereby, in my humble submission, my lord, the impugned notice and the impugned order of the revision is absolutely illegal without jurisdiction, contrary to the express provision of section 21 of the Act, my lord. And thereby, in my humble submission, my lord, the impugned notices and the assessment orders are liable to be set aside and quashed.
Okay. The facts are in other two petitions are.
The same facts are there, because we are not going into the issues of that what was addition, what was deletion. We are on the legal issues, and all the three are common, my lord. The order is also common. So I, lordship may hear the other side, and thereafter, if necessary, I will give reply, my lord.
Mr. Chen. Your time, your turn.
10 minutes only now.
We may continue for 10 minutes. If you require more than that, you can. You continue for 10 minutes and then you may continue after lunch.
I'll pass you your law, the Nagaland Sales of Petroleum and Taxation Act 1967 and the rules also. And my objections and affidavit in reply filed by the petitioner for your ready reference, your lordship. Your lordship, all the actions were initiated by the state and the basis of the act. The Nagaland Sales of Petroleum and Taxation Act 1967 and the rules framed there. So it is, the difference is there. With respectful,
Mr. M. Chen, you have to use microphone.
yes,
Yes.
with respectful, I've heard the respectful submission of my learned senior friend, Mr. Dr. Ashok Sharif, who is an expert in the law of taxation. And he was saying, yeah, so many things, he has brought in so many things before your lordship. Lordship, may kindly turn to page 2 of the state counter.
Let's counter affidavit. Yes.
Lordship, my submissions will always reflect on the act. That is why I have made a written reference on the
Yes.
on the act. Your lordship, may kindly turn to para 3,
Yes.
Roman A. Roman A of the state counter, your lordship, please.
Yes.
Yeah, read it, your lordship.
Yes.
The writ petitioner, without exhausting all the alternative remedies available to him, has approached this honorable High Court by way of this writ petition. Section 19 of the Nagaland Sales of Petroleum and Petroleum Products, including Lubricants Taxation Act 1967, herein after referred to as the Act, provides for appeal provision and an order of assessment or penalty, which reads as. Your lordship will find in section 19 clause 1 of the Act. Any dealer objecting to an order of the assessment or penalty passed under this Act may within 30 days from the date of the service of such order appeal to the prescribed authority under such against such assessment or penalty, provided that no appeal shall be entertained by the said authority unless he is satisfied that the amount of tax assessed or the penalty levied, if not otherwise directed by him, has been paid. Provided further that the authority to whom the appeal is filed may admit it after the expiration of 30 days, if such authority is satisfied that for the reason beyond the control of the appellant or for any other sufficient cause, it could not be filed within time. Section 20 clause 1. Your lordship ready-made will be there in the in the Act, original Act. The commissioner may call for and examine the record of any proceeding under this Act, and if he considered that the any order passed therein by any person appointed under the section 5 to assess him is erroneous, insofar as it is prejudicial to the interest of the revenue, he may, after giving the dealer an opportunity of being heard, and after making or causing to be made such inquiry as it deems necessary, pass such orders thereon as the circumstances of the case justify, including an order announcing or modifying the assessment and directing a fresh assessment. Section 21, clause 1, again, your lordship. Any delay agreed by such order passed in an appeal under section 19 or passed in revision under subsection 1 of the section 20 may appeal to the state government. Your lordship, this is very important. May appeal to the state government within 60 days of the date on which the order is communicated to him. From the above, it is clear that the Act has provided provisions for appeal against the impugned order. However, the petitioner, without availing the alternate remedies has approached the honorable court, and as such, the instant writ petition is liable to be dismissed.
So your submission is appeal against an order passed under section 20
Has to go to this,
state government,
to the state. To the state.
and he has approached this court without exhausting that
Oh,
remedy.
Yes, yes.
Okay.
That is one condition, your worship. And your worship will find that number B, separation of material facts. The petitioner, by suppressing the material facts,
What material facts?
the petitioner, by suppressing the material facts, has approached this honorable court without highlighting the entire facts and thereby mislead this honorable high court. In this context, it is stated that the respondent number 3, having observed that the assessment made against the petitioner's firm for Beirut from 2012 to 2013.
Who is
2000,
respondent number 3 is the commissioner of taxes.
yes, yes.
Okay.
From the Beirut, your worship, petitioner's firm for the Beirut 2012 to 2013 was erroneous. And for further inquiry and verification, notice for revision was issued to the petitioner on 5/7/2019. Lordship, that is before pandemic, COVID pandemic, notice was issued. 5/7/2019, requesting the petitioner to appear in person or show an authorized representative on 19 July 2019 at 11 AM. However, the petitioner failed to comply with a notice without assigning any reason. Lordship, in this context,
This notice was notice under section 20.
correct, Your Worship, correct.
Okay.
So we have issued a notice. In the writ petition, your lordship will find the petitioner has pleaded for violation of the principles of natural justice. Violations of the principles of natural justice, issue of notice. We have issued a notice, lordship. I'll come to the next, your lordship. Thereafter, a reminder was issued on 23/7/2019, directing the petitioner to appear on 30/7/2019 at 1 PM. That is before the pandemic, your lordship.
Okay.
Again, for failure to comply to the notice dated 13/8/2019 was issued, but there was no response from the petitioner, and as such, last reminder notice 12/9/2019 was served on the petitioner fixing 30/9/2000 at 11 AM. It was only after the last reminder notice that one Alok Agrawal, assistant manager, appeared on 30/9/2019 on behalf of the petitioner and submitted a letter dated 30/9/2019 containing the Barawai's reply to the notice 12/9/2019. On examination of the Barawai's reply, it was found that the information sought was furnished partially and many inconsistencies were observed. Therefore, the petitioner was asked to furnish information in full without further delay. Since complete information was not furnished by the petitioner, notice dated 2/11/2019 was served through email to Sri Alok Agrawal requesting to furnish the required information on or before 14/11/2019. Despite such notices and having failed to respond to the same, the respondent authorities on the basis of the record available in the proceeding.
We'll continue after lunch. After lunch we'll. We have Yes, Mr. Inchen, continue.
Yes, your worship. This, before I continue reading the paragraphs again, now. The Nagaland Petroleum. The Nagaland Sales in Development and Taxation Act 1967 was framed under the provisions of the Constitution of India, your lordship.
No, before that,
Under the provisions of the Constitution of India, 304 of the Constitution of India. Read with.
yes.
Read with 166 of the Constitution of India. The formulation of the act, your lordship. 304 and 166 of the Constitution of India.
Okay.
Lordship. In order to comprehend by your lordship, may I continue reading the paragraphs
Yes,
of the state contract?
no, your submission was that notices were issued to the petitioner. In
Yes,
spite of issuance of notice, he
Yes.
he did not appear in all three cases.
yes,
Anything else?
yes. Lordship, paragraph 5 of the state contract is very important, your lordship. Please kindly see the paragraph 5 of the state contract.
Yes.
May I read it, your lordship? Paragraph 5 of the state contract.
Yes,
That the statements made in paragraph 4 of the read petition are not wholly correct and denied by the answering respondent. Answering deponent. The notice dated 28/04/2020 was issued within the limited and provisions of the Nagaland Sales of Petroleum and Petroleum products, including the Lubricants Taxation Act 1967. And that too, after affording several opportunity and reminder notices to the petitioner. As stated in the preceding paragraph, having observed that there were some errors in the assessment for the period 2012 to 2013, the responding authorities have issued notice on several occasions since 07/05/2019. The last been issued on 19/5/2020, which was after the request made by the petitioner for extension of time. The MBO notice 28/04/2020 was issued after several reminders notices as per the provisions of the Act. Section 15 provides that the authority which made an assessment or passed an order on appeal or revision in respect thereof may at any time within 8 years from the date of such assessment or order and of its own motion rectify any mistake evident from the records of the case and shall within the like bureau rectify such mistake as has been brought to its notice by the dealer, your lordship. Provided that no such rectification shall be made having the effect or enhancing the assessment unless the authority concerned has given notice of its intention so to do and allow the dealer reasonable opportunity of being heard. Clause 2, where such rectification has the effect of reducing the assessment, refund shall be due. Clause 3, where such rectification has the effects of enhancing the assessment and notice of the demand shall be issued for the sum payable.
No,
Lordship will
Mr.
come to
Mr. Chen, the submission of learned senior counsel for the petitioner is that notices issued to you by you are not under section 15. It was issued under section 20, clause 1, of which you don't have authority. That is the submission.
no notice, your lordship may kindly produce the act.
Your submission is that under 15 notices may be issued.
Yes.
But
Lordship
the,
may kindly produce the act.
okay,
Everything has been defined in the act.
okay, proceed.
So your lordship, my humble submission is that there is no violation of the principles of natural justice. Because sufficient notice was issued. And the petitioner cannot take the shelter of the COVID-19.
Okay.
Your lordship, that is my submission.
Yes. Dr. Saraf,
My lord,
the one of the main submission was one of the submission which may be relevant that you had opportunity of availing recourse to appeal under section 19 to the
Correct.
state government,
my lord,
even against an order passed under section 20,
absolutely correct, lord.
which you did not avail.
My lord. My lord, two submissions I have heard, lord, my learned friend have made submissions on the ground of natural justice, which I have not addressed at all, because natural justice question will come when somebody has got the jurisdiction. If somebody is acting without jurisdiction, the question of natural justice or violation of natural justice does not arise.
Yes.
So the question of natural justice, that I was given an opportunity. Giving an opportunity to a person will not validate an action which is absolutely without jurisdiction.
You are challenging that notice itself.
I am challenging notice and consequent order itself. So, my lord, the question of natural justice will not arise because, as you are also aware, my lord, if somebody has issued a notice which he is not entitled to or which is not outside the power conferred on him, then only because a opportunity was given to the person concerned will not make the notice or the assumption of jurisdiction to be valid.
Okay.
Now, coming to the issue of the alternate remedy, you'll also will find that the appeal lies, first of all, appeal lies to the government. Now, you'll also see the appeal as per the rules, it lies before the government, secretary to government of Nagaland Finance Department. That you'll also find in the rules. Rule my lord 30.
Yes.
Every appeal to the state government under section 21 of the Act shall lie in so and so addressed to the Secretary to the Government of Nagaland Finance Department.
Yes.
Now this tax act, etc., these are under the Government of Nagaland Finance Department. Even the Secretary to the Government of Nagaland Finance Department is a party respondent here. Because you are also aware that in taxation matters, whenever an action is challenged, then the state must be a party. And state is represented by the Finance Department. Now, when the Finance Department, the action is the Commissioner of Taxes, is under the Finance Department, he is acting under the Finance Department. How an appeal can lie to the Finance Department, Secretary to the Government of Nagaland Finance Department? You also find the respondent in the writ petition. Respondent number 1, Miller.
Yes.
It is state of Nagaland, represented by the Commissioner Secretary to the Government of Nagaland Department of Finance Taxation.
You have made them a party.
May not any petition unless and until the state is made a party, because Commissioner of Taxation is a functionary of the state.
Yes. No, I have not understood. The contention of the London.
That means appeal is there before the state government under section 21.
Yes.
My submission before your lordship is that, my lord, there any action of the Commissioner of Taxes. Commissioner of Taxes is only a functionary of the state. Commissioner of Taxes under the Act is for the purpose of appointment as a Commissioner of Taxes. Your lordship say the state government shall appoint. Your lordship just see the section, my lord. Section 5, my lord.
I'm assuming that it is appointed by the state government.
Well, it is all actions. The state government may, for carrying out the purpose of the Act, appoint a Commissioner of Taxes. So a state government, for the purpose of carrying out the purposes of the Act, shall appoint a Commissioner of Taxes. Now, this Commissioner of Taxes actions, whatever are there, they are for the state government. For the implementation of the Act, the authority which has been appointed is the Commissioner of Taxes. But it is under the Finance Department of the Government of Nagaland. Now, this is my first issue. But secondly, my lord, assuming an appeal lies, whether the writ petition in the present case will be maintainable or not. Your lordship, I will see page 63 of my compilation.
Yes.
So this was a case where the Shiomoto revisional order was subject matter of a challenge before in the writ petition. And your lordship may see paragraph 6 at page 65.
Yes. Paragraph 6.
Hello. May I read, my lord? or I may take your lordship to, first of all, to paragraph 4. Just, my lord. Paragraph 4, my lord. At page 64.
Yes.
Before answering the question, we feel that us to say a few words on the exercise of the writ powers conferred by Article 226 of the Constitution, having come across certain orders passed by the High Courts, holding writ petitions not maintainable, merely because an alternative remedy provided by the relevant statutes has not been pursued by the parties desirous of the invocation of the writ jurisdiction. The power to issue prerogative writs under Article 226 plenary and nature. Any limitation on the exercise of such powers must be traceable in the Constitution itself. Profitable reference in this regard may be made to Article 329 and the ordinaments of the other similarly worded articles in the Constitution. Article 226 does not in terms impose any limitation or restraints on the exercise of the powers to issue writs, while it is true that exercise of writ powers, despite ability of the remedy under the very statute which has been invoked and has been given rise to the action impugned in the writ petition, ought not to be made a routine matter. Yet the mere fact that the petitioner before the High Court in a given case has not pursued the alternate remedy available to him, it cannot mechanically be construed as a ground to dismissal. It is axiomatic that the High Courts, bearing in mind the facts of each particular case, have a discretion whether to entertain a petition or not. One of the self-imposed restrictions on the exercise of powers under 226 that has evolved through judicial precedents is that the High Court should normally not entertain a petition where an effective and efficient remedy is available. At the same time, it must be remembered that mere availability of an alternate remedy of appeal or revision, which the party invoking the jurisdiction of the High Court under Article 226 does not invoke, would not outset the jurisdiction of the High Court and render a writ petition not maintainable. In a long line of decisions, this court has made it clear that availability of an alternate remedy does not operate as an absolute bar to the maintainability of writ petition, and that the rule which requires a party to pursue the alternate remedy provided by a statute is a rule of policy, convenience, and discretion rather than a rule of law. Though elementary, it needs to be restated that entertainability and maintainability of writ petition are distinct concepts. The fine but real distinction between the two ought not to be lost sight of. The objection as to maintainability owes to the reach of the matter, and if such objections were found to be sustained, the court would be rendered incapable of even receiving the list for adjudication. On the other hand, the question of maintainability is entirely within the realm of discretion of the court, writ remedy being discretionary. A writ petition, despite being maintainable, may not be entertained by the High Court for many reasons, and the relief even could be refused to the petitioner despite setting up a sound legal ground if grant of the claimed relief would not further public interest. And dismissal of a writ petition by High Court on the ground that the petitioner has not ever that may do it without, however, examining whether an exceptional case is made out for such incident would not be proper. A little after the dawn of the Constitution bench of this court in the decision rendered in so-and-so has occasion to observe as gender. In the next place, it must be borne in mind that there is no rule with regard to the certiorari, as there is with mandamus, that it will lie only where there is no other equally efficient remedy. It is well established that provided the requisite grounds exist, certiorari will lie, though a right of appeal has been conferred by the statute. The fact that the aggrieved party has another and adequate remedy may be taken into consideration by the Superior Court in arriving at a conclusion as to whether it should exercise its discretion, issue a writ of certiorari to quash the proceedings and decisions of inferior court subordinate to it, and ordinarily the Superior Court will decline to interfere until the aggrieved party has exhausted its other remedies. But this rule requiring the exhaustion of the statutory remedy before the writ court will be granted as a rule of policy, convenience, and discretion rather than a rule of law. And instances are numerous where a writ of certiorari has been issued in spite of the fact that the aggrieved party has other adequate remedies. At the end of the last century, this court in paragraph 15 of the decision in Worldful so-and-so carved out the exceptions on the existence whereof a writ would be justified in entertaining writ petition, despite the party approaching it not having availed the alternate remedy provided by the statute. The same read agenda, where the writ petition seeks enforcement of any fundamental rights, where there is a violation of principal natural justice, where the order or the proceedings are wholly without jurisdiction, where the virus of an act is challenged. Not too long, this court in decision reported in so-and-so, Assistant Commissioner has dictated the same principles in so-and-so. That apart, we may also usefully refer to the decision of the court in so-and-so. What appears on a plain reading of the former decision is that whenever a certain item falls into an entry of the statute, raises a pure question of law, and investigation into facts is unnecessary, the High Court could entertain writ petition in discretion even though the alternative remedy was not availed of. And unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. In the later decision, this court found the issue raised by the appellant to be persistent legal requiring determination of the High Court without putting the appellant through the meal of the statutory appeals in this hierarchy. What follows from the said decision is that where the controversy is purely a legal one, where the controversy is purely a legal one, and it does not involve disputed question of fact, but only questions of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of alternate remedy being available. Thereafter, similar. Now, reverting to the facts of the appeal, we find that the appellant had claimed before the High Court that the Suomoto revisional order power could not have been exercised by the revisional authority in view of the existing facts and circumstances, leading to the only conclusion that the assessments were legally correct and that the final orders impugning the petition were passed upon assuming the jurisdiction which the revisional authority did not possess, exactly which submission which I made below. In fine, the orders impugned were passed without jurisdiction. Since the jurisdictional issue was raised by the appellant in the writ petition questioning the very competence of the revisional authority to exercise the Suomoto power, being a pure question of law, we are of the considered view that the plea raised in the writ petition did deserve a consideration on merits, and the appellant's writ petition ought not to have been thrown out at the threshold.
Okay.
Thereafter, also see para 11, Miller. We have reasons to believe, considering the nature of the objection raised by the respondents as recorded by the High Court in the impugned order, that the High Court had mistakenly referred to Titagarh paper mill by intending to rely on a different decision of the court on the appeal preferred by the same party. While upholding the impugned order of dismissal of the High Court petition where the order passed by the state officer was under challenge, this court in so-and-so held that the challenge being confined to the regulatory proceedings before the said officer, and there being no suggestion that the concerned officer no jurisdiction to make assessment, the decision in so-and-so was clearly distinguishable. Since in that case there was a total lack of jurisdiction, this court also held that under the scheme of the relevant act, there was a hierarchy of the authorities before which the petitioner can get adequate redress against the wrongful acts complained of, and since the authority of the concerned officer to make an assessment was no question, the course ought to have been taken by the proceedings thereunder. As noted above, the very jurisdiction of the revisional authority having been questioned in the petition, the impugned order of the High Court dismissing the petition without examining the merits of the challenge cannot be sustained even if the High Court were relying on so-and-so. Now, in the case before the apex court also, Miller, the Suomoto revisional order was under challenge on the ground that the authority had no jurisdiction to initiate the Suomoto revisional proceedings, and the apex court held that under such circumstances, the writ petition could not have been dismissed on the ground because the jurisdiction question was under an issue before the High Court, Miller. So this judgment of the apex court, recently given, Miller, in 2023 itself, squarely covers the case in hand, and thereby, in my humble submission, the argument raised by the Learning Council for the respondents, Miller state, has no merit on the ground of the alternate remedy. Now, one more point, Miller, you'll also see the notice. At page 36, Miller.
Yes.
Your Lordship find the notice was under section 20 of the Nagaland Sales and Petroleum Act.
Yes.
And this was for the purpose of the assessments made under the Nagaland Petroleum Act notice. Now, in the order which has been passed, you'll also find at page 30, my lord, the order, final order, my lord, at page 39. This is both under the Nagaland Petroleum Act as well as the Central Sales Tax Act.
The order.
My lord.
Yes, central sales tax.
Now, once the proceedings, if any initiated, assuming, my lord, for the argument's sake, my lord, that the proceedings are valid, assuming. Once the proceedings were initiated only for Nagaland Petroleum Act, how the, my lord, the order can be passed also under the Central Sales Tax Act?
Okay. The first paragraph of the order itself, page 39, my lord. Okay, what is your submission?
My lord.
What is your submission in this regard?
Well, the submission is that, my lord, even if assuming for the argument's sake, my lord, it is considered that the notice was issued and notice is valid. But that notice also was only for under the Nagaland Petroleum Act. If the Nagaland Petroleum Act only the proceedings were initiated, how the final order can also be passed under the Central Sales Tax Act?
No notice was issued under Central Sales Tax Act.
No notice. You also seen the notice. There was no notice that the assessment made under the Central Sales Tax Act were also erroneous or were wrong. So, my lord, to summarize the submissions, although your lordship has noted every submissions below, that the Shiomoto revisional proceedings, which were initiated by the Commission of Taxes, were to verify whether the returns were submitted by the all requisite papers and documents or not, and whether the due amount of tax had been paid or not, which does not come within the purview of the order being erroneous and prejudicial interest of revenue, and thereby the assessment order, the order is notice itself is bad. Secondly, the Commission of Taxes himself has mentioned that it is for the purpose of the escapement of turnover and due amount of tax. Escapement of turnover will not come within the provision of section 20 of the Act because there is a separate provision itself, and thereby the proceeding is illegal. Thirdly, my lord, the commissioner can exercise the powers only by calling for the records of the proceedings. Here, the commissioner has not examined the records and has not come to the conclusion on the basis of records of the proceeding. He is saying that further verification and documents are necessary. Thereby, he is trying to find out, say that you produce the documents and papers and I will re-verify and thereafter come to a conclusion which is not permissible under section 21 of the Act as per the various decisions of division bench of this local court as well as the apex court. Next, my lord, the Commissioner of Taxes, having issued a notice under the Petroleum Act, could not have made the assessment under the Central Sales Tax Act also. The Commissioner of Taxes, having passed the order, has no power to make the assessment himself because the power to make the assessment is on some other authority, and Section 21 says that he can direct for making a fresh assessment. There is no power to make the fresh assessment himself. The Commissioner of Taxes, while coming to the conclusion, has not come to a prima facie conclusion that the order is erroneous, only simply writing in the words which are used in the section that order is erroneous will not make the order to be erroneous, because from the plain reading of the order itself it shows that the Commissioner of Taxes was not examining the records and not examining that whether the order was in accordance with law or not, but is making a fishing and roving inquiries into the affairs which has already been concluded. So in my humble submission, my lord, the objection which has been raised are only twofold, that natural justice and the alternate remedy. Alternate remedy, my lord, I place the judgment of the directly on the Supreme Court on the issue, and natural justice, according to me, my lord, will not come in the way, because if the order is without jurisdiction, then whatsoever hearing you may give, the order will not become valid. That is my humble submission to summarize, my lord. So return in order.
Yes, your lordship. If your lordship has heard my senior friend, Dr. Sherwin a lot. Now, your lordship, I just want to make one point. Here.
It's not the order. It's against the
To
order.
approach this court for invoking the extraordinary jurisdiction under your lordship is well aware under 226 of the Constitution of India. Petitioner has to exhaust all his legal remedy.
No, that
No.
he has submitted, sure. On that point, you have also submitted.
Now, and again, the petitioner has not challenged the very act. He has not challenged the provisions of the act, your lordship, under which we have taken the action.
Well, why I should challenge the provisions of the act? Because I am saying the action is without jurisdiction. Why I should challenge the provisions of the act? In a proper case, a person may authorize, may take the exercise the powers in Section 20. I'm not saying.
Okay, anything else? Dr. A.K. Saraf, Senior Counsel, assisted by Mr. What's your name? K.V. Nagi. Also heard in all three cases, huh?
All three cases.
Also heard Mr. Mo Aim Chen, learned Senior Government Counsel appearing for the respondent authorities. Hearing concluded, judgment reserved.
My lord, my name of one of the junior who is assisting in Gauhati may also be recorded, my lord, Mr. Pritam Barua.
Assisted by Mr. K.V. Nagi and Mr.
P. Barua,
and Mr. Pritam Barua.
my lord. My lord, one more thing, my lord, you also wanted to know about the other act. My lord, I've gone through the Tripura Sales Tax Act also. There also all the powers were with the commissioner. Because my lord.
Okay.
It was delegated thereafter, but all powers under the act were with the commissioner.
Okay.
So Rajendra Singh judgment, which I placed before Lordship, the two judges, the division bench judgment, my lord, that was Tripura Sales Tax Act. And the Tripura Sales Tax Act also, my lord, all powers were with the commissioner.
Okay.
I'm grateful to your Lordship, my lord, for a patient hearing, my lord. I got an opportunity to argue for Lordship, at least sitting in Kohima.
Oh, I got an opportunity to learn from you.
No, my lord, your Lordship, such a patient hearing, and that too through virtual mode. My lord, I'm really grateful to your Lordship. My lord, I'm obliged.
Yes, Dr. Farooq.
May I please, minutes? So item number 2 minutes. It was time fixed matter, minutes. So minutes, my colleague minutes, Lucino will hand over minutes a copy of the complaint which we were able to get minutes with regards to parent, and so minutes would absolutely right minutes. If a copy may kindly be perused minutes.
Yes, this is.
So, my lords, yes, my lords. So what has happened, my lords, that the counsel being engaged by my client there in parent, my lords, instead of getting copy from the court, he got copy from the opposite counsel. So that's why that happened, my lords. Now, my lords, may kindly see para 17 at bottom page 9 of this certified copy, my lords. So the contents are same, my lords. I will just show one aspect, my lords, for my lords' perusal. Para 17.
Yes.
Yes, my lords. Thus, the complaint through its counsel issued a statutory notice dated 2nd March 2023, which was sent on 3rd March 2023 by speed post, thereby calling upon the accused persons to pay the aforesaid check amount within 15 days from the issuance of the aforesaid notice. However, despite mentioning the last known address of the accused persons in the above said legal notice, the same was returned on account of address being inaccurate. It is pertinent to mention that even after the best endeavor of the complainant, the current address of the accused person could not be traced. Therefore, the complainant is constrained to prefer the present complaint before this honorable court. Now, my lords, may juxtapose this with the main petition, that is at page number 68 of the paper book. Page 68.
Yes.
Now, my lords, this para 17 and the para 17 I have read right away from the certified copy, my lords, are same, my lords. Now, my lords, in addition thereto, I will request Ms. Lucino to hand over for my lords a copy of the order dated 17/4/2023.
But in the 68 of the paper book, you have annexed the complaint which was filed at Dimapur.
No, my lords. So what has happened, my lords? My lords, and I tender my apologies. What has happened, my lords, that the copies which we have annexed with the paper book in the quashing petition was the copies which somehow my client local counsel in Peren obtained from the opposite counsel instead of he getting that copy from the court records. Now, the copy which I have handed over today, if my lords may kindly see, that that bears the stamp from the page card to CGM Peren. Now, I was trying to show, my lords, the para 17 that complaint are same. So it would be a case, my lords, that the petitioner, the complainant would have filed a petition with the counsel. His counsel would have the copy with the Dimapur original, and at the time of filing, he would have changed. But I was just trying to satisfy my lords with para 17, which is a crucial para insofar as my case is concerned.
Yes.
And my lords may kindly see, check involved, I will show para 10 from this certified copy. My lords also posed a query with regards to check number. So para 10 my lords of this certified copy may kindly be seen. Para 12, I will rather read, my lords, that the complainant, based on accused person's false and misleading assurances, presented check number 291328 dated 4th February 2023 for rupees 40 lakh. Now, my lords, may kindly see this from the impugned order. The impugned order may kindly be seen. That is at page 47 of the paper book.
Yes.
That my lords, before that, if my lords may kindly see 17/4/2023 order, which my colleague would have handed over.
You have supplied. Yes.
So, my lords, this is an order passed before the impugned summoning order. So, my lords will see in this 17/4/2023 order. Now, my lords may kindly see that's a 40 lakh rupees is mentioned. The learned counsel for the complainant submitted that complainant bank account is in Jaluki SBI. However, since 40 lakh rupees is a huge amount which could not be withdrawn in SBI Jaluki, the branch manager made an endorsement on the check and asked the complainant to withdraw it from SBI main branch Dimapur. Thereafter, when the check bearing number 291328, the same check was presented, it bounced with the remark payment is stopped by the drawer.
No, it was presented to at bank at Dimapur.
Yes, my lords, this is what the order says. That's why 200 inquiry is being done.
Then
It says, my lords,
if it is presented at Dimapur, how the jurisdiction of parent court would lie?
that is a pilots. That's precisely, my lords, the next submission would be pilots. That even the territorial jurisdiction, pilots. Yeah. No, my lords, in this respect, my lords, I will be fair to concede, my lords. If my lords may kindly see section 142 of the NI Act.
Yes, what it says.
142, my lords, cognizance of offense is the heading. And at the last, my lords, an explanation has been appended.
What it provides.
I will read, my lords. For the purpose of clause A, where the check is delivered for collection at any branch of the bank of the payee or holder in due course, then the check shall be deemed to have been delivered to the branch of bank in which the payee or holder in due course, as the case may be, maintains the account. And my lords, it is this explanation, my lords, in my respectful submission and with limited knowledge of law, my lords.
Jaluki falls within parent. Where does Jaluki?
Lordship, I think so, your lordship. Yes.
Where is
My,
Jaluki? Anybody in the court?
it's under parent lordship.
District, your lordship.
Parent.
Yes, yes.
Okay. Okay, then it is okay.
So only, my lords, I will confine my submissions with regards to the admitted position in para 17 of the complaint, my lords, where the complainant itself is saying on oath, my lords, that the legal notice was not delivered because of incorrect address. On the previous dates, my lords, I have shown the same address, my lords, notices being exchanged between the parties. And my lords, I have also shown to my lords, for my lords' perusal, that with regards to the first check out of these 4 stolen checks that was presented in Rohini branch of Yes Bank at New Delhi. Thereafter, the notice was issued. I have replied to that notice. The complainant opted not to file the case in New Delhi, my lords, and in order to intimidate and harass, he all together went to parent, my lords, open a bank account, present a check, and implicate me in a false case, my lords.
Section 138.
Yes, my lords. 138, my lords, may kindly see.
What is
B and C are relevant, my lords. I will read. The payee, or I'm reading B, my lords. The payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of check within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid. And C, the drawer of such check fails to make payment of the said amount of money to the payee, or as the case may be, to the holder in due course of the check within 15 days of receipt of said notice. Now, my lords, in this premise, my respectful submission would be this, my lords, that until and unless the notice in question is delivered to me, my lords, and even during that 15 days windows which the Act provide, the offense under 138 will not be deemed to have been committed. It is only, my lords, that when I receive a notice and after 15 days, I fail to discharge that liability, then and then only, my lords, in my submission, the offense under section 138 would be deemed to have been committed.
And your submission is that in this case, admittedly, the complainant himself is saying that notices are not delivered.
Yes, my lords. I have read para 17 from the certified copy, and I have juxtaposed for my lord's perusal from the paper book. Although, my lords, for the time being, I will pray, my lords, not to rely on the paper book contents of that nomenclature and only to appreciate, my lords, this certified copy extract, my lords, from which I have read para 17. And I have also shown to my lords 17/4/2023 order, my lords, which bears the same check number, qua which the complaint has been filed and qua which the summoning order impugned herein has been issued, my lords.
You have to bring this parent order on record.
Lordship, I can file an affidavit, Lordship.
Because it has to be brought on record.
I will file an affidavit, my lords, and along with this, my lords, I also seek liberty, my lords, this from this honorable court, since on account of this particular complaint being annexed, certain annexing numbering will be necessitated to be changed in the petition. So either I may be permitted to amend the petition, my lords. No, the only difficulty, my lords, why I am not praying for withdrawing with liberty to file, because tomorrow is the date at parent, my lords, and the learned trial court will proceed to issue non-bailable warrants, my lords. So my lords may only protect for some time for tomorrow anticipated coercive action, my lords. And in next 7 days, my lords, I will take all the, my lords, I will physically come. I will have this, my lords, privilege of appearing before my lords in a physical mode, and I will get these all done, my lords.
No. Now I may not even issue notices also without your correcting the complaint, correcting the petition. Because
Yes, my lords, I bow down to this, my lords, but my lords will only appreciate, my lords, this court is not bereft of the power in my respectful submission, my lords. The only thing, my lords, that tomorrow they will issue bailable warrants have been issued, my lords. Now, my lords, will consider that petitioner number 3 is women, my lords, she has two young children, my lords. So everything will fall apart, my lords. That's the only respectful submission I can make. I'm at my lord's hand, my lords.
you rectify the petition first.
I will do that, my lords. But in the meantime, my lords, I can only pray, my lords. I beseech this honorable court with great respect, my lords, to protect me from the coercive action for tomorrow, my lords.
Or that
Even some observation, my lords, even if this honorable court deems fit, my lords, I pray that the matter be listed tomorrow before parent court be adjourned, my lords. Only this, my lords, that will suffice meeting my requirement, my lords, on account of the pendency of this petition before the Honorable High Court.
Doctor. This is item number
2, my lords. Item number 2.
His name is not reflected in the cost.
What is his name? I forgot his name.
My name is Farooq Khan, my lords.
Farooq Khan, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioners, namely Messrs. Partha Projects, number 1. Number 2, Major Vikas Chillar, within bracket retired. Number 3, Miss Sonam Singh, praying for quashing the complaint case bearing number 2/22/23 under section 138 of the Negotiable Instrument Act, 1881, which is pending before the Court of Chief Judicial Magistrate, Peren, Nagaland. Learned counsel for the petitioner has submitted that the learned Chief Judicial Magistrate, Nagaland, has taken cognizance of offense under section 138 of NI Act before, as without considering the fact that it is apparent from the materials which were placed before the learned Chief Judicial Magistrate that the notices which the respondent number which the respondent number which the sole respondent as complainant of the said complaint case has claimed, has himself stated in the complaint petition as not being served on the present petitioners. However, and therefore learned counsel for the petitioner submits that the ingredient of section 138 clause
B, my lords.
B and
C, my lords. B and C, my lords.
B and C, where it is mandated that a reading of which would show that the offense of under section 138 of the Negotiable Instrument Act, 1881 is committed only after lapse of 15 days period of the date of receipt of notice issued to the accused person, issued to the would, what is the line?
Recipients may be, my lords.
Issued to the persons who issued the check in question. Drawer, issued to the drawer of the check. You will be the drawer of the check.
Yes, my lords. Yes, my lords.
Drawers of the check. However, in the instant case, the pleadings made in the complaint petition as well as the affidavit in evidence on affidavit submitted by the complainant.
My lords, if I may take a pause, I'm so sorry, my lords. As of now, my lords, I only have been able to obtain this complaint copy where para 17 is there, my lords, because I'm not sure, my lords, that evidence affidavit, that Dimapur and Pareen, my lords. So I should be fair with the court, my lords.
Okay. Complaint petition shows that the notices were not served. Stop. On the complaint, on the present petitioners. Stop. Learned counsel for the petitioner further submits that there are certain, due to inadvertence, some wrong documents were annexed, some defective documents were annexed along with the complaint petitions, which are required to be rectified. Now, what is your prayer? How will you rectify?
My lords, will give me 7 to 8 days, my lords. I can file an amended petition, my lords.
And seeks leave of this court for, no, you have to file an amended petition
Yes, my lords.
and submits that the petitioner would be filing an application for amendment of the petition under section 482. The prayer is allowed. the petitioner is allowed to file an amendment petition seeking amendments in the criminal petition as he desired. However, learned counsel for the petitioner also submits that the complaint case number 2/23 is fixed before the court of learned Chief Judicial Magistrate Peren on 18
Yes,
18/6/2018,
10 minutes.
18/10/2023, that is tomorrow. And learned counsel for the petitioner submits that in view of the prayer for amendment in the instant criminal petition, he may also be allowed 7 days time in the complaint petition, in the complaint case, which is, your prayer is for this prayer.
My interim is for a stay, my lords.
No, stay I am not considering now. Before your
So, my lords, may only protect me that by appearance through the council, my lords, the court will not take any coercive action.
your counsel will be appearing now.
Yes, my lords, some council will appear, my lords.
What was the last line?
He may also be allowed 7 days time.
He may be. The court may also grant for why you are anticipating that the.
My lords, but there is more what meets the eye, my lords. I should not say this, my lords. Even warrants have been issued, my lords. The last order, 29/9/2023, my lords, the bailable warrants have been already issued, my lords. So when I won't appear, my lords, the non-bailable warrants are bound to follow, my lords. So, my lords, may only protect me that for till the next date of hearing before this honorable court, or for the 10 days or 15 days, whatever my lords deem fit, that my appearance, my lords, my exemption application through council would be allowed, my lords. That should do, my lords, in my respectful submission.
What was?
He may also be allowed 7 days time in the complaint case, which is.
Now, as. As in, it is also submitted that as in the complaint case pending before the court of Chief Judicial Magistrate, which is fixed on 18/10/2023. Already bailable warrants have been issued against the present petitioners. So, some time may be granted to the petitioners to appear in the said court. And on the next date fixed, that is 18/10/2023, the petitioners may be allowed to appear before the learned trial court through their appointed counsel. Considering the submissions made by learned counsel for the petitioner and as well as facts and circumstances of this case, and considering the fact that already the prayer for filing a petition for amendment of the instant criminal petition has been allowed, the petitioner is allowed to appear before the court of learned Chief Judicial Magistrate Peren in complaint case number 2/23 through their appointed counsel, and the court shall, and the learned trial court shall allow the prayer for dispensing the personal appearance for tomorrow only, if such prayer is made by learned counsel for the petitioner. Enough. let this matter be listed on after 2 weeks. You want it to be fixed
Yes, my lords,
unless you file a amendment petition,
my lords.
notices would not be issued here.
Yes, my lord. So I will file that within 7 days, my lords. Any day, my lords, may kindly,
After 7 days. Let this matter be listed after a week.
any fixed date, if my lords may give, my lords.
On fixed date would be 30th of October only,
My lords, I'm deeply grateful, my lords.
30th of October.
I'm so deeply grateful, my lords. Deeply obliged, my lords. Grateful, my lords. Grateful.
My apologies, Lordship. Lordship, if it can be on the 31st, since we'll be filing the amended petition on the 30th,
Okay.
and if
okay.
the matter can be on
No,
the
if you want-
31st. Lordship.
In the first week of November, I can also accommodate.
Yes, my lords, first week of November, my lords.
Lordship, second of November.
2nd of November.
So deeply grateful, my lords. Obliged, my lords. Grateful. Grateful.
Much obliged, Lordship.
For hearing item numbers 12 to 14.
No, before that, Mr. Longkumar, you're waiting since morning.
Yes, my lord.
Your bail application, you have to see orders later on. The prayer is rejected. I'm rejecting your prayer because the cough syrup,
Yes, my lord.
which is seized, it consists of not permissible limit of codeine. It consists of codeine which is beyond permissible limit, not. It is available in the
Market. Lordship.
Google also. The
Yes.
composition is available. So you have to see the order tomorrow morning.
My lord, if in that case, the application can be considered on the ground that the investigation has been stagnated and there's no progress to the investigation, and so on that line, if my lord can kindly consider to enlarge
No,
the.
I have
and
already
impose
delivered my,
impose-
you have to see only orders tomorrow.
impose any other conditions that may be appropriate.
Section 37, when I have observed that section 37 embargo is applicable, then my hands are tied.
But my lord, even yesterday, the Learned Council, the BP was also saying that at this point, the investigation, there's no further incriminating evidence against the accused, so that he can be enlarged, because there was if there's no objection from the other side, the embargo also, section 37 says that there should be given an opportunity to the prosecutor to make an objection on the ground.
You have to wait till
Yes.
tomorrow.
My lord, I'm just humbly praying before the honorable Lord to consider on other lines also.
Yes, Mr. Chair.
I offer my unconditional apology that I was not present when the matter was called up. Because I was under the impression that it would be taken up to PM.
Will it be over by today?
No.
Unlikely.
Your lordship.
There is another unlisted
Oh.
motion is there. Let us take up that motion. Unlisted motion and then there.
May I please, your lordship? Lordship, 438 Valley Please, your lordship. relevant portion of the FIR page 11, Lordship.
Offense is under
379. There is no specific allegation against me, Lordship. There is no, I am not the FIR name Prakash, Lordship, but
Then-
I am the owner of the vehicle, Lordship.
owner of the what vehicle?
On board carrier vehicle, Lordship, bearing registration number LNL7AF0123, Lordship. Page 11, Lordship.
That vehicle was stolen.
No, Lordship.
Ah.
The actual fact is that the petitioner purchased the vehicle to run in Nagaland for commercial purpose, Lordship. Initially, the petitioner engaged the informant, Lordship, to collect, to look after the vehicle as well as to collect the daily earned money, Lordship. Accordingly, after a few days, the informant proposed the petitioner that he will give him sum of rupees 1,40,000 per month on contract basis, Lordship. And accordingly, petitioner agreed. But since the month of January, Lordship, 2023, the informant stopped to pay the said amount, Lordship. And accordingly, the petitioner took back his vehicle, Lordship. Petitioner is from Assam, Lordship. He is residing in Huzai district, Lordship. So thereafter, the informant has filed the FIR, Lordship, saying that his vehicle is stolen. He is claiming this vehicle on the strength of page 21, Lordship, on sale deed, Lordship. Page 21, annexure 5. But there is no signature of the petitioner in the said sale deed, Lordship. Unfortunately, it is also notarized by the notary public, Lordship. Very unfortunate, Lordship. Page 24, Lordship. There is no signature of the seller, petitioner. And till date, the petitioner is paying the installment of the vehicle. Page 21, second prop from the bottom, Lordship, and whereas, Lordship. And whereas the purchaser agreed
What is
to-
your name?
My name is Lordship Samsul Haq. Page 24, Lordship. There is-
Now, why are you apprehending arrest?
Lordship, because of this FIR, Lordship, police searching me, and since the vehicle is in my custody, Lordship, I am the owner. Yes, that's why the vehicle is in my custody. Police searching me because the vehicle is in my custody, Lordship. Page annexure to page 13, Lordship, RC, registration, Lordship. Name of the petitioner is shown, Samsul Haq. It was registered on 22nd October 2022, Lordship. Then, Lordship, recently I have updated my insurance, Lordship, insurance of the vehicle, Lordship. That is annexure 3, page 14. 4/9/2023, Lordship. Then, Lordship, EMI, annexure.
Yes, Mr. Zimomi. You appear before I.
Yes, Lordship.
Let him appear before I. You call for the case diary.
Lordship.
In the meanwhile, let him appear before the IO.
Lordship.
Okay.
Yes, Lordship.
Heard Mr.
Yes, Alam, Lordship.
S.
Alam.
S. Alam, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned public prosecutor, Nagaland. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Samsul Haq, who is apprehending his arrest in connection with Medzi Fema Police Station case number 18/2023, corresponding to GR case number 575/2023 under section 379 of the Indian Penal Code. The gist of accusation in this case is that on 30/5/2023, one Costo Ria lodged an FIR before the Medzifema police station, Chumukidima, Nagaland, inter alia, alleging that the first informant has purchased the goods carrier vehicle bearing registration number NL 07AA 0213 from the present petitioner, and on 30/5/2023 at about 30/5/2023 in the early hours of the morning, someone has stolen the said vehicle. So, learned counsel for the petitioner has submitted that the present petitioner is the registered owner of the vehicle bearing registration number NL 07AA 123, and he had, and why you have given the vehicle to the first informant?
Lordship,
Agreement was there.
no, Lordship. I engaged him to look after the vehicle, and also
And he had engaged the first informant to look after the vehicle.
and also to collect the daily earned money, Lordship, by the vehicle, Lordship.
And also to collect the daily income out of the said vehicle. However, and so, however, learned counsel for the petitioner has submitted that the informant has annexed one sale deed showing that the present petitioner has sold the said vehicle to the first informant, which the learned counsel for the present petitioner denies, as the sale deed which is annexed with the FIR lodged against the present petitioner does not contain the signature of seller, and it contains the signature of the purchaser, that is first informant only. Learned counsel for the petitioner has also submitted that the petitioner, that when the first informant stopped paying the daily income out of the vehicle which was given to the first informant, the present petitioner took away his own vehicle, and the said vehicle is now in his possession. It is also submitted that the present petitioner is ready to cooperate with the investigating officer. So, on the other hand, Mr. V. Zumomi, learned public prosecutor, has submitted that perusal of the case diary may be necessary for consideration of the instant bail application. Hence, call for the case diary, fixing 31/10/2023 for case diary. However, in the meanwhile, considering the fact that the present petitioner appears to be the registered owner of the vehicle which is subject matter of the FIR, he is hereby directed to appear before the investigating officer of Medzifema Police Station, case number 18/2023, within a period of 10 days from the date of this order, and cooperate with him in the investigation. If he does so within the said period, within the stipulated period of time, in the event of his arrest in connection with Medzifema Police Station case number 18/2023, he shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the condition that he shall cooperate with the investigating officer. Let this case be again fixed on 31/10.
Lordship, After vacation, maybe, Lordship.
31 is after vacation.
After vacation.
31 till 5, Lordship, vacation is, will continue. Lordship.
5 is the vacation of principal seat.
Lordship,
Okay,
maybe-
you want the next date fixed to be on 5th, on 6th.
Maybe on 8 or 9, Lordship. November.
Let this case be fixed again on 8th of CD date, also 8th. But you have to appear before IO
Yes,
within
Lordship,
10
I will.
days.
Master.
Yes, Mr. Chaudhary. We have many part-heard matters. Mr. Imchen, Jamir, Moa Jamir. Your matter is also part-heard. Which we should take? Which one is in the seriatim?
This one is above here. This is the number one.
Because it will take time. It will take,
Not completed today.
it will, and there,
Complete of them.
No, no, it doesn't come. It only comes.
If his submission is short, then for me to, I can complete.
because,
I won't take much time, yes, but
It's better, the 3 matters are.
and because their matter is almost near completion.
Then your lordship. Let, I'll wait. If it has, then I.
even if we wait also, we cannot take up to do.
It will not be finished by today.
No, no.
Then tomorrow also,
Yes, division. bench.
then I am left with only one day.
Tomorrow we can take a chance of. A lot of matter get agenda, so can take a chance tomorrow.
Tomorrow, I will have to.
Then this has to be,
I have a division bench. again.
After division, after division.
No, that also- I have 3.
Very good. If it
So
continue-
either on the Thursday or
after vacation.
No, no, no. The urgency is there. Then I start with that. Urgency is there, you see. Urgency is there. That's right.
No, we don't have time. actually.
otherwise, if almost lordship on the BPC criminal level is almost completed. And all these things are interconnected
No,
only.
no,
It
yeah.
doesn't need to
Your
rely
Honor,
much on that one.
Your
yes.
lordship, two cases are different,
No,
different things has to
What
get.
is the difference?
Case
Your
record,
Lordship?
everything is there, everything has to go into it. Otherwise, you get confusion, your lordship.
No,
So that's,
No, therefore I'm putting queries to you.
yes, your lordship.
Will it be possible within 1 hour to finish it?
No, no.
It is not possible.
Your lordship may fix it tomorrow, I'll take a chance for tomorrow.
no, tomorrow too.
Tomorrow she is not,
Yes,
You're in, no, she's in DB, the DB breaks, then she's got a second start.
I cannot, your lordship.
Because because tomorrow I'll continue the.
See, your lordship, yeah, your lordship, but I cannot tomorrow, your lordship.
Tomorrow she won't have to, tomorrow I'll take the tomorrow that. Tomorrow, I stick.
I don't think that we may hear this matter because we don't have time. You will not be able to finish it within 1 hour.
No, 1 hour, your lordship. It, this better, seeing this better, it get agenda.
Tomorrow is DB is fixed.
Yes, sir. But DV
And
lot of
after-
matter get agenda, sometimes. Your lord-
That,
I want to take a chance.
no,
No,
Then Thursday, top of the list, Thursday. Top of the list, Thursday.
if he makes his submission short, then your lordship.
No, it
Otherwise,
cannot- it has to be.
for the
explained, your
last 2
lordship.
days, your lordship.
it will be wastage of time
Exactly,
because unless we have time available,
yes.
Thursday, I should, if I get a sufficient time, I will.
No, your lordship, because see, almost all the facts he has covered. So the other 2 question is
No,
for
no.
question of the FIR and the charge.
Your
sheet.
Honor,
Only
your
when
Honor,
he.
I know
is-
what is to be
when
argued.
He can't satisfy this court by the,
Question is there, question. I have
by
to
the
argue.
judgment of the Supreme Court. We can only go on the fact, only on the law point
No, no,
only.
that facts are also
Yes,
there.
And he
Question-
has submitted many things on that, your lordship. So
no, now make submission. When to hear?
I can continue tomorrow also. Your lordship.
on Thursday, your lordship,
Tomorrow I can, because I'll take second, wait,
Oh,
No,
how can-
unless-
I
unless-
say I have a difficulty. How
No,
can
no,
you
no, I'm not
insist
saying-
on
I'm not-
yes?
she's having DB matter, because after DB break.
No, I cannot do on that after DB also.
Third. Let us fix it on Thursday.
Yes, sir,
Mm.
at the top of the list.
Lordship on Thursday, yes.
Thursday, if possible, if it is possible for you to complete within 2 hours,
Yes.
See, yes,
because Thursday we have fixed matters also.
at the top of the list. Your Lordship.
No, there is already some other case fixed on the top.
It can be top ever. I was the top.
Even on top of, he won't reach on time. That's a problem.
Then it is.
Otherwise, we could
No,
have
it was
finished
not
today,
that.
Your
It was
Lordship.
fixed for 2 o'clock today, Your Lordship. That's why, it's not that I didn't reach in time. It was fixed at 2
Heard
p.m.
Mr. Praveer Chaudhary, learned counsel for the petitioner. Also heard Ms. V. Sokre, learned public prosecutor, Nagaland. Learned counsel for both sides submits that this case would require a long hearing and it may not be possible to finish the hearing today itself. And therefore prays for listing this matter on Thursday. The prayer is allowed. Let this matter be listed on 19th of October.
At the top of the list. Otherwise, go down at the top of the list.
No, because there are other council have prayed for top of the list requests.
Let it be also, let the registry do the lottery. Otherwise, it go
On
down.
Thursday. On Thursday, you may make mention in the morning. If other council concedes, we may take it up as the matter first item. I am not reflecting it in the order sheet.
Keep level.
Yes, let us complete Mr. Jamir's.
May it please Lordship.
Yes,
Lordship, may I take 2 minutes to just refresh this honorable court's mind, Lordship,
yes.
on the facts which has stated yesterday, Lordship. They're all together 3 petitioners, Lordship. They're all serving as LDA computer assistant under the Social Welfare Department, Lordship. Now, they were appointed in the year 2011 and 12 respectively, Lordship, on different dates, all the 3 petitioners. As on today, they have completed 10 or more years of service, Lordship. Now, Lordship, the government of Nagaland, through the Personal Administrative Reforms Department, they have formulated policy, Lordship, on 2 occasions. That is, first is on 4th August 2008, and the subsequent is on 11 August 2016. These are the 2 office memorandums, Lordship. Now, as per the office memorandum, regularization of contract or ad hoc service has been provided, Lordship. The employees who have completed 3 or more years of service, they are to be regularized, Lordship, provided they fulfill the eligibility criteria. The first criteria is there should be a sanction post, Lordship. Second is, Lordship, there should be a suitability test. The test has to be conducted by a committee, Lordship.
Availability of posts
Availability of post, Lordship.
and suitability tests.
Suitability test, Lordship. So I have to face the test. And if I'm being found qualified, Lordship, my name would be recommended for regularization, Lordship. Now, what has happened, Lordship? Subsequently, the department has issued a notification. Notification is in the year 2016 for conducting of suitability test. Now, not only for LDA, Lordships, various other posts were also being conducted, Lordship. And I have faced the test, Lordship, and subsequently I have qualified all the tests. My names, the petitioners, along with others, their names were forwarded to the government for approval for regularization, Lordship. Now the matter that's being situated, what has happened, Lordship? the account that is the petitioners in the WPC number 145. They approached this honorable court by filing WPC number 145 of 2017, Lordship. It was disposed of in the year 2018. Now, in that read petition, Lordship, a challenge was made to various posts, Lordship. To be more specific, 705 posts were challenged, Lordship, on the ground that their appointments were made without any selection process in violation of the constitutional scheme for public employment, Lordship. Second is, Lordship, this two office memorandum, which I'm relying upon, Lordship, these two were also being challenged, Lordship. Now, Lordship, the outcome of the read petition was that it was dismissed on the ground, question of maintainability, on the ground of maintainability, Lordship.
Yes.
Lordship, while dismissing the application, the petition, Lordship, observation was made on that two office memorandum that on the employees who have completed only 3 years of service, their service may not be regularized. That was the observation meant, Lordship. After dismissing that application, Lordship, the petitioners have approached the department for regularization of their services by way of a representation.
Why
Lordship.
this observation was made?
Observation was made that only 3 years, Lordship.
No, why this observation was made? Why it was made?
On the ground that this is not in the line with the Umadevi's judgment, Lordship. That was the observation.
Okay.
Umadevi says that it has to be 10 years, Lordship. State has formulated policy, only 3 years, Lordship.
Oh, that was the logic.
Lordship. As per my understanding, Lordship, and that has also been discussed, Lordship. Now, after dismissing the read petition, Lordship, the petitioners subsequently approached because their matters were kept pending, Lordship, for some time due to the pending of the read petition. But after disposing of the read petition, in fact, after dismissing the read petition, the matter was kept pending for a considerable period of time, Lordship. Being aggrieved, we have approached the department by submitting representations to consider our case on the ground that we have faced the interview board. We are eligible, and we were appointed against sanction post. We fulfill all the eligibility criteria to be appointed as LDA computer assistant, Lordship. Those were the grounds we have. Now, after submitting the representation, nothing was done, Lordship. No positive outcome. It was kept in cold storage, Lordship. Therefore, before this honorable court.
Now you have a problem.
Yes, Lordship. No, Lordship, for all fairness, I should also apprise before this honorable court that against the judgment of the learned single judge, the state has preferred an appeal, which was also dismissed, Lordship. While filing the read petition, Lordship, I could not get a copy of the outcome of the appeal, Lordship. If I may be allowed to finish the judgment and order passed in the appeal, Lordship.
Why state preferred an appeal?
State preferred an appeal that there are certain observations were made in the office memorandum, Lordship, though it was not interfered with. State has preferred an appeal. If I may be allowed to read the relevant paragraphs, the Lordship will have a clear picture of what has happened, Lordship.
Yes.
It's a very short order, Lordship, if I may be allowed to read from the facts, a little bit of the facts, as well as the observation made by the Honorable Division Bench, Lordship. May I start from paragraph 3? Lordship will find it page 2. This is read appeal 16 of 2018. This was disposed on 7 of February 2019, Lordship. May I read, Lordship?
Yes.
Paragraph 3, Lordship. Mr. So-and-so Leonard Senior Additional AG placed before the court the office memorandum dated 4/8/2008 of the state government in the Department of PNR pertaining to regularization of contract ad hoc appointments against sanction post, by which the state government partially modified its office memorandum dated 23/8/2007 and ordered that contract employees who have completed more than 3 years of continuous service on contract ad hoc basis will be eligible for regularization against sanction post in terms and conditions that: 1, there should be a sanction post. 2nd, the employee should fulfill all eligibility criteria for the post, including the requisite education qualification. 3, the state OM shall not apply the post where there are pending court cases, and that 4, state OM shall not apply where the posts have been already requisitioned for filling up through the MPSC, Lordship. If your Lordship may kindly turn to paragraph 4, Lordship. The appellants also placed before the court that In the said OM dated 4/8/2008, it has been specified that there shall be a suitability test to be conducted by the concerned departments under the chairmanship of the head of the administrative department, with representative from the Personnel and Administrative Reforms Department and Administrative Training Institute, Nagaland, Kohima. And that the qualifying marks would be laid down in advance, and only those who qualify, such as screening test, would be considered for regularization. In the said OM dated 4/8/2008, it was also stipulated that the concerned departments after such screening shall submit specific cases to the government for its approval for obtaining the recommendations of the screening committee that comprises of the so-and-so. 5. Mr. So-and-so plays another office memorandum bearing number so-and-so 6616 before the code that was issued by the state government in the Department of PNR, wherein it is specified that from the date of issuance of the said OM, no appointment shall be made on contractual basis, meaning thereby that the appointment on contract basis was banned, and further observed that a post coming under the purview of NPSC can be filled up only by appointing a candidate recommended by NPSC on the basis of open recruitment, and such post cannot be filled up even temporarily in any other manner, and that any appointment made thereafter on contract basis shall be null and void. 6. The appellant stated that the respondent number 1 as a read petitioner earlier preferred appeal so-and-so. Lordship, this may not be relevant, so if I may be allowed to read from paragraph 10, Lordship. Yes. It starts with the observation of the Honorable Court, Lordship, Division Bench of this Honorable Court, Lordship. May I read it? Paragraph 10. From the perusal of the read petition number 145K of 2017, that was the petition which was dismissed by the single bench, Lordship. Preferred by the petitioners, the respondents herein, as well as the impugned judgment and order dated 3/8/2018, passed therein by the learned single judge. We have seen that a prayer in the said read petition, amongst others, was to set aside and quash the impugned office memorandums dated 4/8/2008 and 11/8/2016 of the state government, by which the state allegedly provided for regularization of the backdoor appointees who were appointed on contract ad hoc basis in public post under the state government prior to the office memorandum dated 6/6/2016, came into force and have completed 3 years of such service. In the said read petition, the petitioners have also prayed for termination of service of such 706 backdoor appointees in government service, serving in various departments of the state, who were appointed prior to 6/6/2016, and to direct this Nagaland Public Service Commission for general recruitment to those 706 posts under various departments of the state within time-bound period. The contentions of the read petitioners in the said WPC 145 was that the state respondents decided to regularize all those backdoor appointees made by the state and public post under various departments of contract ad hoc basis in terms of those OMs dated 4/8/2008 and 11/8/2016 in violation of the directions of the Honorable Supreme Court in the case of State of Karnataka versus Umadivi, reported in 2006 for SSC 1. 11. From the impugned judgment dated 3/8/2018, we have seen that the learned single judge, after deliberating the matter at length, found that the action of the state government in regularizing the employees who have completed 3 years of continuous service on contract ad hoc basis in terms of said OM dated 11/8/2016 as well as OM dated 4/8/2008 is in violation of the law laid down by the Apex Court in case of Umadivi. Para 28 of the impugned judgment and order dated learned single judge observed that 28. The judgments of the Apex Court, as quoted above, thus clearly gives primacy to advertisements before filling up vacant posts as per the recruitment rules in force. The state respondent should accordingly consider filling up the regular vacant posts under the state government as per the law laid down by the Apex Court, and any contract ad hoc employee who is appointed to the post of contract basis should also be eligible to participate in the selection process, provided the person is eligible for the same as per recruitment rules and it's not regularized as per para 53 of Umadivi. In view of the law laid down by the Apex Court, any contractual, temporary or ad hoc appointments made without prior advertisements being issued in the media, including newspapers, will be violative of Article 14 and 16 of the Constitution and liable to be set aside and the said post filled up as allowed as per law. However, the question of filling up the said post will only come into play after the state respondents have taken recourse to para 53 of Uma Devi. 13, learned single judge in the said judgment, when order dated so and so, observed that the petitioners made a sweeping challenge to the appointments made in various grades of posts in approximately 25 government departments, thereby trying to brush aside all alleged irregularities and illegalities with one sweep of the broom. And that is, it is very difficult for the court to see through the facts of the case in the absence of complete material facts. In respect to the challenge made to 706 allegedly irregular or illegal appointments, as such, the petitioners were allowed to file separate petitions, making a challenge to the various appointments by giving specific particulars as their grievances relates to different appointments in different department of the government of Nagaland, observing that the said writ petition cannot be decided piecemeal. 14, for such reasons, the learned single judge, though found that the said writ petition is not maintainable in the form the petitioners had filed the same, but it gave the liberty to them to make a fresh challenge to the appointments of the impleaded respondents and other persons as below. Since the writ petition was not dismissed on merit, but only on the issue of maintainability. This is also important, Lordship. 15. However, with regard to the order dated so and so passing PIL number so and so, the learned single judge observed at the best that the same is applicable to the petitioner number 1, only and not to other petitioners of the said writ petition. 16. The Constitution bench of the Honorable Supreme Court in the case of Uma Devi at para 53 observe as follows. 53, Lordship. One aspect needs to be clarified. There may be cases where irregular appointments, not illegal appointments as explained in so-and-so case, and referred to paragraph 15 above of duly qualified persons in duly sanctioned vacant posts might have been made and the employees have continued to work for 10 years or more, but without the intervention of courts of the orders of the courts or of tribunals. The question of regularization of the services of such employees may have to be considered on merits in the light of the principles settled by this court in the above referred cases and in the light of this judgment. In that context, the Union of India, the state governments and their instrumentalities should take steps to regularize as a one-time measure. This is important, Lordship. The service of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts, but not under cover of orders of the courts or tribunals, and should further ensure that regular recruitments are undertaken. This covers my case, Lordship, to fill those vacant sanctioned posts that require to be filled up. In cases where temporary employees or daily wages are being now employed, the process must be set in motion within 6 months from this date. We also clarify that regularization, if any already made, but not subsidized, need not be reopened based on this judgment. But there should be no further bypassing of the constitutional requirement and regularizing of or making permanent those not duly appointed as per the constitutional scheme. 17. The Honorable Apex Court decided the said case of Uma Devi on so and so. In the case of Uma Devi, their lordships have specifically observed that regularization of service of only irregular appointees can be considered as not of illegal appointees. Further regularization of those irregular appointees who are duly qualified persons placed against in duly sanctioned posts who have continued to work for 10 years or more without any intervention of courts or tribunals can be considered. The Honorable Apex Court in the said case further observed that regularization of such category of irregular employees have to be considered, that too on merits in the light of the principles stated, settled in the said Honorable Court as laid down in the case of so-and-so, so-and-so. Accordingly, by the said judgment, the Honorable Court directed the Union of India, the state governments and their instrumentalities to take steps to regularize such irregular appointees as a one-time measure and directed authorities to ensure that regular recruitments are undertaken to fill up those vacant sanctioned posts that are to be filled up in cases where temporary employees or daily wages have been employed, and such process of regularization should be set in motion within 6 months from the date of judgment, that is 10 April 2006. Para 18, Lordship. In the said judgment of so-and-so, the Honorable Apex Court with regard to such regularization of services of irregular appointees clarified that based on the judgment, if any regularization is already made, but not subsidized, such cases should not be reopened. At the same time, the Honorable Apex Court issued a strict rider that there shall be no further bypassing of the constitutional requirement and regularizing or making permanent of those who were not duly appointed as per the constitutional scheme. 19. As such, in terms of the impugned judgment of so-and-so, anyone appointed in violation of scheme on or after so-and-so are not entitled for regularization, and that to only those irregular appointees who were duly qualified illegal placed against duly sanctioned posts have completed minimum of 10 years of service as on so and so, and serving without any intervention of courts from the court or tribunal can be considered for regularization of one-time measure, subject to the condition that the Union of India, the state governments in their instrumentalities, as the case may be, initiated a process of such regularization within a period of 6 months from 10th April 2006, that is the date of the judgment. 20. The Honorable Apex Court have already settled as to who are irregular appointees and who are illegal appointees in service. With regard to public employment and posts under the government, where salaries are paid from public state largely, it is settled that when an illegality is brought to the notice of the court in a judicial proceeding, more particularly in a proceeding under writ jurisdiction, the court cannot shut its eyes and allow the authorities to continue such illegalities. Para 21 Lordship. The learned single judge in the impugned judgment and order dated so and so, passing so and so, found that the action of the state government regularizing the service employees who have completed 3 years of continuous service on contract in terms of those office memorandums is in violation of the law laid down by Honorable Apex Court. As such, the impugned decision of the learned single judge so and so disposing of the writ petition being not maintainable in the form it was filed, without dismissing the same on merit and granting liberty to the petitioners of the state writ petition to make a fresh challenge to the appointments of the implemented respondents therein and other persons as per law. We are of the view that the learned single judge did not commit any illegality in directing the state respondents, the appellants herein not to regularize any person who has completed only 3 years, Lordship, of continuous service on work church ad hoc basis in terms of those office memorandums noted above, as those OMs are found to be not in conformity to the law laid down by Honorable Apex Court in the case of Umadevi. Accordingly, we are of the opinion that the directions and observations made in the impugned judgment and order passed by the learned single judge does not call for any interference. For the reasons above, this appeal being devoid of merit stands dismissed, Lordship.
So para 22 is important,
Lordship.
where it says that not to appoint who have completed. You are emphasizing on the word only,
Lordship. Yes, Lordship.
but the division bench also said that the single bench, while making an observation that not to appoint only on the basis that they have completed 3 years in terms of OM.
Lordship.
Perhaps therefore the state is not appointing you.
Lordship. In the first place, Lordship, I agree that this office memorandums, Lordship, 2008 and 2016, which was subsequent to the Umadevi's judgment, Lordship, there is a clear direction given under paragraph 53 of Umadevi's judgment. All the state governments in the country, Lordship, to come up with a one-time measure by way of any policy, Lordship, to accommodate who were appointed on irregular basis, not on illegal basis, Lordship.
And who have completed 10 years.
Who have completed 10 years, Lordship. However, Lordship, I admit the fact that the state government has come up with this policy. Only 3 years, Lordship. Only 3 years. However, Lordship, the question of law that has to be considered at this stage, Lordship, whether those OMs, though those observations were made, Lordship, and my respectful submission before this honorable court is, these are observations of this honorable division bench of this honorable court, Lordship, observations. Now, whether by making those observations, whether the office memorandum 2008 as well as 16 has been interfered, question set aside, Lordship. That is also one aspect that has to be considered, Lordship. Secondly, Lordship,
Okay.
whether an observation made by the division bench of this honorable court, Lordship, can it be used as a precedent, Lordship? There are several judgments of the Honorable Apex Court, Lordship. I'll be relying on a few of those judgments, Lordship. Few judgments on observation, whether it can be used as a precedent, Lordship. Secondly, Lordship, the office memorandum has not been interfered. That is my respectful submission before this honorable court. In other words, the two office memorandum, whether legally or illegality, Lordship, formulated by the state government, still holds the field. That is my respectful submission, Lordship. On two counts, Lordship. First, the learned single judged, while dismissing it, has made some observation, but the office memorandums were not interfered with. State has preferred and appealed. Division bench, Honorable Division Bench of this Honorable Court, Lordship, has also made similar observations, but it has not been interfered. Thirdly, Lordship, if I may be allowed to take your Lordship to some records that in the year 2011, Lordship, altogether five LDA computer assistants, equally and similarly situated persons, they were also regularized, Lordship. And the law is also very clear, Lordship. I'll be relying on a Supreme Court judgment on the question of Article 14, Lordship. Equality before the eye of the law, Lordship. I have also enclosed one of the decision rendered by this Honorable Court, though that is pertaining to a different department, Lordship. Of recent times, one of LDA computer assistant, he has also approached this Honorable Court. This Honorable Court has given a direction to consider his case, Lordship. I have also enclosed it as part of my petition, Lordship. Lordship will find it page 96, the last annexure in my read petition, Lordship. It is order dated 9th August 2021, Lordship, passed in WBC number 134 of 2021. Direction was given to the state respondents, particularly the Department of Food and Civil Supplies, Lordship, to consider for regularization. These are only few instances where similar situated cases were also being considered, Lordship. Now, Lordship is well aware of all the facts.
After this judgment of DB and single bench,
Lordship,
this similarly situated persons were given advantage by this court.
Lordship.
After this DB and SB judgment.
Yes, Lordship. It was in the year 2021, Lordship. If I may be allowed to take the Lordship to page 96, Lordship. The bench was rendered in the year 2019, Lordship, and this is order dated 9 August 2021, Lordship. To be more specific, after 2 years of the Honorable Division Bench has rendered this decision, Lordship. Page 96, Lordship. Annexure S, Lordship, page 96. It's towards the end of my petition, Lordship. The Lordship got it. Yes. This is order dated. Lordship will find the order at page 97, 9/8/2021, Lordship.
Yes.
May I read the relevant portion, Lordship, from the second subparagraph, the fact, page 97, Lordship. May I read it, Lordship?
Yes.
The fact of the matter is that the petitioner is appointed as LDA computer assistant in the Directorate of Food and Civil Supplies, Nagaland, Dimapur, by order dated. It is in the year 2011. Similarly, with the present petitioners, they were also appointed in the year 2011 and 10. Lordship. By notification dated so and so, the petitioner, along with other 2 employees, underwent suitability test for regularization. A similar process was also undergone, Lordship. The file for regularization was forwarded to the Secretary to the Governor of Nagaland, Department of Food and Civil Supplies, by the Additional Director, by letter dated so and so. Till date, the service of the petitioner has not been regularized. And without considering the case of the petitioner, the state respondents have made several appointments on regular basis without following any process of selection in the department. This shows that they are regular sanction posts, Lordship. However, the petitioner's case was not considered and other appointments were made. There is also a government order dated so and so, wherein it has been notified that ad hoc employees who have completed more than 3 years of continuous service are to be considered for regularization. A representation dated so and so was presented before the concerned authority. However, no steps have been taken by the department for regularization of the service of the petitioner. Hence, the present read petition to direct the state respondents to regularize the service of the petitioner as LDA computer assistant. The state respondents are represented by the so and so, who submits that the representation of the petitioner is under consideration. Therefore, he has prayed that the matter may be disposed of with a direction to the respondents to dispose of the representation of the petitioner. I have heard the learned counsel for the parties. Considering the submissions made to parties, I am of the opinion that the matter may be disposed of with a direction to the state respondents to consider and dispose representation of the petition at the motion stage, Lordship.
That was on the concession of the council for the.
Lordship. That was in the year 2021, Lordship. If I may be allowed to place reliance on some authorities, Lordship, since the facts has already been understood by this honorable court, Lordship. And the facts are very simple, Lordship. Subsequent to the disposing of the single bench, the writ petition as well as the appeal, Lordship, I have made several representations which was not considered, Lordship.
Yes.
Lordship, this is a compilation, if I may be allowed to refer only to the relevant paragraphs, Lordship, to save this precious time of this honorable court, Lordship. If I may check your Lordship to page 7 of my compilation, Lordship.
It's a 100-page compilation. Okay, continue. Page 7.
Page 7, Lordship. This is a citation of AIR 1968 SC 647, Lordship. The citation, Lordship, will find in the first page, Lordship.
Yes.
It is on the question of a decision is only an authority of what it actually decides. What is of the essence of a decision is its ratio, that is the principle, Lordship. May I take the Lordship to page 7, Lordship? I'll rely only on the relevant portion of the paragraph, Lordship. It starts from a decision towards the bottom of the second last paragraph, Lordship. It is on the fifth line decision, if your Lordship call it. A decision is only an authority of what it actually decides. What is of the essence in a decision is its ratio, and not every observation found therein, nor what logically follows from the various observations made in it. Lordship, it's with regard to the observation made by the learned single judge as well as the division bench, Lordship. If I may be allowed to continue, Lordship. Now, before discussing the case of Allen versus Flood, what was decided therein? There are two observations of a general character which I wish to make, and one is to repeat what I have very often said before, that every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generality of the expressions which may be found there are not intended to be expositions of the whole, be governed and qualified by the particular facts of the case in which such expressions are to be found. The other is that a case is only an authority for what it actually decides. I entirely deny that it can be quoted for a proposition that may seem to follow logically from it. Such a mode of reasoning assumes that law is necessarily a logical quote, whereas every lawyer must acknowledge that the law is not always logical at all. This is the observation made in the year 1968, Lordship. I may be allowed to take your Lordship to the second authority, Lordship will find it page 11, Lordship. This is 2004 at 8 SC 579, Lordship. In the case of Bharat Petroleum, Lordship. Page 11, Lordship. The relevant paragraphs are 9 and 12, Lordship will find it page 16. Page 16, if your Lordship got it. Page 16, the running page.
Yes.
Paragraph 9 at the bottom, Lordship. May I read it, Lordship?
How much time will you take more? How much more time?
Lordship, I'll be relying only on these decisions and I will conclude my submission.
How much?
I won't take much time.
Otherwise,
5 to 8 minutes something.
I see that it is spilling over to tomorrow. Because we have only 15 minutes left.
Lordship.
Continue.
Lordship, the convenience of this honorable court.
No, you continue till.
Lordship.
You
I'll try to
may-
conclude at the earliest
least
slot.
You may conclude,
Lordship.
then we may hear him.
Yes. Lordship. I rely only on the relevant paragraphs, Lordship. I'll try to minimize the time, Lordship. Paragraph 9, Lordship.
There are 9.
Page 16, Lordship.
Yes.
Courts should not place reliance on decisions without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. Observations of court are neither to be read as Euclid's theorem nor as provisions of the statute, and that too taken out of their context. This observation must be made or read in the context in which they appear to have been stated. Judgments of court are not to be construed as statutes. To interpret words, phrases, and provisions of statute, it may become necessary for judges to embark into lengthy discussion, but the discussion is meant to explain and not to define. Judges interpret statutes, they do not interpret judgments. They interpret words of statutes, their words are not to be interpreted as statutes, Lordship. Paragraph 12, Lordship, the same page, page 17, paragraph 12, Lordship. The following words of so-and-so in the matter of applying precedents have become locust classicist. Each case depends on its own facts, and a close similarity between one case and another is not enough because even a single significant detail may alter the entire aspect. In deciding such cases, one should avoid the temptation to decide cases by matching the color of one case against the color of another. To decide, therefore, on which side of the line a case falls, the broad resemblance to another case is not at all decisive. Precedent should be followed only so far as it marks the path of justice. But you must cut the dead wood and trim off the side branches, else you will find yourself lost in branches. By my pleas to keep the path of justice clear of observation which could impede it. The next citation, Lordship, will find it page 21, Lordship. Page 21, Lordship. This is the next citation, 2007 1 SEC 92, page 92, Lordship. The relevant paragraph starts from 11, Lordship. Page 21, Lordship. Page 21. Relevant paragraph starts from paragraph 11, Lordship will find it 25. My apologies, Lordship. Page 25, relevant paragraph 11, Lordship. It discusses about Uma Devi's case, Lordship. This was passed in the year 2007 after Uma Devi's judgment was rendered, Lordship. Paragraph 11, Lordship. And this is important for my case, Lordship. Learned counsel for the appellant has relied upon the decision of this court in the case of State of Karnataka versus Uma Devi, and has urged that no direction for regularization can be given by the court. In our opinion, Lordship, the decision in Uma Devi case is clearly distinguishable. The said decision cannot be applied to a case where regularization has been sought for in pursuance of Article 14 of the Constitution. Similar situated cases were considered, Lordship. I should also be considered, that is the observation, Lordship. Next paragraph is para 16, Lordship. Lordship will find it page 27. Para 16, page 27, Lordship. We are constrained to refer to the above decisions and principles contained therein because we find that often Uma Devi case is being applied by courts mechanically. This is very important, Lordship, as if it were a Euclid's formula without seeing the facts of a particular case. As observed by this court in so-and-so case, a little difference in facts or even one additional fact may make a lot of difference in the precedential value of a decision. Hence, in our opinion, Uma Devi case cannot be applied mechanically without seeing the facts of a particular case, as a little difference in facts can make Uma Devi's case inapplicable to the facts of the case. Lastly, Lordship, paragraph 18, page 28, Lordship. Paragraph 18, page 28. I'll read only the first sentence of the para, Lordship. We may further point out that a 7-judge bench decision of this court in so-and-so case has held that reasonableness and non-arbitrariness is part of Article 14 of the Constitution. It follows from the government that the government must act in a reasonable and non-arbitrary manner. Otherwise, Article 14 of the Constitution would be violated. So in some case is a decision of a 7-bench Manika Kandi's decision, Lordship, whereas Umadevi's case is a decision of 5-judge bench of this court. It is a well settled that a smaller bench decision cannot override a larger bench decision of this court. No doubt, Manika Kandi's case does not specifically deal with the question of regularization of government employees, but the principle of reasonableness in executive action and the law which it has laid down, in our opinion, is of general application, Lordship. That is also important in my case, Lordship. Now the next citation, Lordship, 2011.
Before that,
Lordship.
how many judges were there in this division bench?
This
na?
present judgment, Lordship.
Is a division bench. judge.
It is a division bench, Lordship, division bench. UP State Electricity Board case, Lordship, 2007. It's a division bench, Lordship. With regard to the precedent, whether it can be operated as precedent, Lordship, just one paragraph, only one paragraph, Lordship. Citation is 2011, 12 SSC 615, page 40, Lordship. I'll take the Lordship only the relevant page, Lordship, 40.
Yes.
Paragraph 21, Lordship. It is now well settled that a decision of this court, based on specific facts, does not operate as a precedent for future cases. This is important, Lordship. Only the principles of law that emanate from a judgment of this court, which have aided in reaching a conclusion of the problem, are binding precedents within the meaning of Article 141, Lordship. It is my respectful submission, Lordship, the judgment rendered by the single judge, as well as the Honorable Division Bench, Lordship. These are not precedents. That is my respectful submission, Lordship. Those are just observations, Lordship. It has not been questioned set aside. It cannot be used as a precedent against my case, Lordship. That is my respectful submission. Now the next paragraph, the citation, Lordship, 1996, 6 S3, page 44, Lordship. Relevant, page 51, Lordship. Page 51. Relevant paragraph is para 10. Para 10. Lordship, I'll take only a couple of minutes, Lordship. I'll conclude my section.
Yes. We'll continue up to 4:15.
Lordship. I'm grateful, Lordship. Para 10, Lordship. Page 51, para 10. May I read it, Lordship?
Yes.
Therefore, in order to understand and appreciate the binding force of a decision, is always necessary to see what were the facts in the case in which the decision was given, and what was the point which had to be decided. No judgment can be read as it is instituted, as if it is instituted. A word or a clause or a sentence in the judgment cannot be regarded as full exposition of law. Law cannot be afforded to be static, and therefore judges are to employ an intelligent technique and the use of precedents, Lordship. I'll stop there, Lordship. If I may be allowed to take your Lordship to the next authority, Lordship.
Yes.
2006 5 SSC 167, Lordship.
Page.
Paragraph 12, Lordship. Paragraph 12, page 62, Lordship, 62. I'll rely only on the relevant paragraph, only one paragraph, paragraph 12, Lordship. Page 62, Lordship. If your Lordship got it?
Yes.
It is in that context of the court clearly came to the opinion that the provisions of subsection so-and-so of section so-and-so were not required to be complied with. The said conclusion was arrived at inter alia so-and-so. It was therefore not necessary for the bench, which utmost respect, to make any further observation. It was not warranted in the facts of the said case. A decision, it is well settled, is an authority for what it decides, and not what can logically be deduced therefrom. The distinction between a dicta and obiter is well known. This is important, Lordship. Obiter dicta is more or less presumably unnecessary to the decision. It may be an expression of a viewpoint or sentiments which has no binding effect. It is also well settled that the statements which are not part of the ratio decidendi constitute obiter dicta and are not authoritative, Lordship. My respectful submission, Lordship, the decisions rendered are not ratio decidendi. Those are statements or observations made by the Honorable Court, Lordship. Next, Lordship, if I may be allowed to take the Lordship to the next edition, 2007, 7 SSC 555, Lordship, paragraph 53. Page 65, Lordship. Page 65, Lordship. At the bottom of the page, Lordship, it starts paragraph 53, Lordship. The observation of this code regarding the linking of word aforesaid from the words of no steps as aforesaid are commenced for its acquisition. If I may be allowed to take on the Lordship only to the relevant Lordship before the code, Lordship will find the 8th line of the next page, Lordship, 8th line. It starts with thus observation of the court, Lordship.
Yes.
May I read it, Lordship?
Yes.
The observation of the court did not relate to any of the legal questions arising in the case, and accordingly cannot be considered as part of ratio decidendi. Hence, in the light of the aforementioned judicial pronouncements, which have well settled the proposition that only the ratio decidendi can act as a binding or authoritative precedent, it is clear that the reliance placed on mere general observations or casual expressions of the court is not of much avail to the respondents. It has no binding effect or it has no authoritative precedent. That is my respectful submission, Lordship. Now, in a similar case of this honorable court, if your Lordship may kindly allow me to take your Lordship to page 70, Lordship. This order was passed in WPC number 172K of 2018. It is order dated 14 September 2018. Altogether, 11 medical officers, they approached this honorable court, Lordship, for regularization.
They were contractual employees.
Lordship. Okay. Now, page 70, the last paragraph, Lordship. Page 70, last paragraph. May I read it, Lordship?
Yes.
After hearing the learned counsel for the parties on consideration of the materials available on report, this writ petition is disposed of at the motion stage, directing the Commissioner and Secretary to the Government of Nagaland Department of Health and Family Welfare. Respondent number 2, to consider representation dated so made by the petitioners and dispose of the same by speaking order in consonance, Lordship, this is important, with OM dated 4/8/2008. The same OM, Lordship. Let such exercise be completed within a period of 3 months from the date of receipt of a certified copy of the order by the respondent number 2. Till the consideration is made by the respondents, the position of the petitioner should not be disturbed. Lordship, the next authority, Lordship, it was rendered in the month of July 2023 by the Honorable Apex Court, Lordship. Page 73, the relevant paragraph, Lordship. Page 73, relevant paragraph is para 7, Lordship. If I may be allowed to refer to a couple of paragraphs, Lordship. This will be this second last authority I'll be relying, Lordship.
Yes.
Para 7. In the Constitution Bench judgment of this court passed in Umadivi, though the court has held that backdoor entries should not be permitted, it has permitted one-time measure to be conducted for regularization of the services of these employees who had completed the service of more than 10 years. 8, in dispute within, the appellants herein have completed service of more than 10 years. Even this court in the case of so-and-so decided on 13 March 2018, found that the act of regularizing the service of some employees and not regularizing the service of the others is discriminatory and violative of Article 14 of the Constitution, Lordship. This also applies, squarely covers my case, Lordship. Para 10, Lordship. Lordship will find it next page, page 74, paragraph 10, Lordship. we are not inclined to accept the submission on behalf of the respondents. When the Chief Commissioner of Income Tax has himself found that 65 persons were entitled to be regularized, the act of regularizing the services of only 35 employees and not regularizing the services of other employees, including the appellants, is patently discriminatory and violative of Article 14 of the Constitution of India. Lordship. Those are the authorities that I'm
In
relying on.
your case, the government is not appointing only because of observations made,
Lordship.
whether that has been communicated to you,
No, Lordship, it has not been communicated at any
But-
point of time, Lordship.
but likelihood that only because of observation.
Lordship. And for all fairness, Lordship, we were verbally informed that, of course, no formal order, no formal communication, but it has been kept pending, Lordship. And with due respect to the officers, Lordship, since they are laymen, Lordship, they are under the impression that it has been disturbed or questioned set aside, and that is the reason why it has been kept pending, Lordship. It is not only for this department, Lordship,
No, it has been kept pending. Why? Because
because of the opinion that the office memorandum, the two office memorandum, 2008 and 16, it has been
Violative
questioned
of-
set aside. That is maybe that is the impression. That is my humble understanding, Lordship.
Mr. Tiba form on day after tomorrow.
After tomorrow.
Because you will take some time,
It's only,
not within 4 minutes.
no. At least it will take 10 minutes.
We are left with only 4 minutes. So we'll keep it part heard.
Lordship.
He's heard Mr. Moa Zamir. Moa Zamir,
Lordship.
London Council for the petitioner. He concludes his part of submissions. However, as regards submissions, however, submissions on behalf of the state by Mr. E. Tiba form is yet to start. Hence, let this matter be listed again on 19th October as part heard matter. As part heard matter. At the top of the list, because we'll hear this one first,
Obliged.
because others are also part heard.
Yes.
Otherwise, we'll miss the
Yes.
bus
Lordship. Grateful, Lordship. So grateful.
on
Okay, my lord.